My lord, I may be allowed to move an urgent unlisted motion, my lord, regarding a selection process to the post of commissioner and secretary under the Assam Civil Services, my lord. The cadre strength is 4, but without any gradation list, and a consolidated gradation list of incumbents consisting of 900 officers were made. I was on the top of the list, but I was not given any appointment. And the selection is to be held on merit with due regard to seniority as per rules, my lord. And
When will the selection be held?
my lord, no, there was total silence, my lord. Nothing was informed to us, not even the gradation list. Gradation list we got from the website, my lord. My name was on the top, but incumbents were 900, my lord.
All right, tomorrow, motion.
Obliged.
Yes, please, Your Lordship. I beg to mention for listing of case, my lord. In one case, my lord, 2018 case, that quarter has been occupied in as per the stay order, my lord. That may be listed on last February, any date from 20 to 23rd February, my lord. And another is almost in fact was go to 2018 letter. Yes.
May please, Your Lordship. I would like to move forward for unlisted motion today, my lord. My lord, what has happened, my lord? The petitioner, from a judgment from this High Court, my lord, the petitioner was granted his seniority from his date of initial joining. We have, even after communicating that order to the department, what is the department has done? They have come up with a order yesterday, whereas they have handing over the charge to an officer junior to me, my lord. And if the same is not stayed, my lord, I'll be highly affected.
Tomorrow.
My lord, if by tomorrow the charge will happen.
Yeah, I can't help it. Tomorrow.
My lord,
Tomorrow, these are not matters of unlisted. Tomorrow.
my lord, my seniority will be affected, my lord. So
No, it will not be.
Contempt of the judgment of this court, my
It will
lord.
not be affected. If we find you have a case, we'll protect it.
My lord.
Tomorrow.
May I please, Your Lordship? Lordship, I beg to mention item number 47 of the daily list, my lord. Matter may be adjourned for the day, my lord. Consent has been taken from the other side, my lord. We have to file our affidavit, my lord.
You are appearing for whom?
For Khadi board, my lord.
On the request of learned counsel appearing for the Assam Khadi,
For the all the respondents.
huh?
All the respondents, Khadi.
Appearing for the respondents made with the consent of the other side. This matter stands adjourned for 3 weeks so as to enable the learned counsel to file affidavit.
Max obligement.
May I please, Your Lordship? Lordship, I beg to mention item number 2 and 30, Lordship, of hearing corpus, Lordship. Lordship, this matter
Item number 2 and
30, Lordship, of hearing corpus, Lordship. The Lordship may kindly adjourn this matter for today, Lordship. It may come up next week, Lordship.
My lord, with the concern of the other side, I'm mentioning item number 32, my lord. In this, my lord, we're supposed to receive these records, my lord. We have received it this morning, my lord. So, my lord, within the offer, so my lord will fix a date, any date, my lord, any hearing date, my lord.
you are appearing for whom?
I am appearing for the respondents, my lord. We have received PWD, my lord. I have received the records today.
You have informed the other side.
She's
I'm from petitioner.
Acha. With the consent of the opposite party, Mr. R. Dhar Leonard, SC PWD 6, posting of this matter again after 10 days by submitting that the records necessary for consideration of this matter has been received by him.
my lord.
The departmental records has been received by him only this morning. First step, since the prayer is not opposed, same stands alone, let the matter be listed accordingly.
Lordship, if possible, that may be.
After 10 days, after 10 days. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention one rate petition pertaining to the pensionary benefits of the petitioner, Your Lordship. The matter was listed on 7/9/2022. Thereafter, it is not listed, Your Lordship. Any date in the next week, Your Lordship.
Third week you put a date, 3rd week of February.
Oblige, Your Lordship.
May I plead, Your Lordship? I am on behalf of Mr. A. Islam, Lordship. And I beg to mention item number 36. The A. Islam is out of station, Lordship, and he adjourned for the date.
As paid
36.
for by petitioner's counsel, this matter stands adjourned for 3 weeks.
Your Lordship, I beg to mention a 2022 matter, Your Lordship, for listing the matter pertains to fixation of the senior petitioner's pay. I'll leave it to Your Lordship to fix a date as per Your Lordship's statement.
1st week of March.
I'm reading.
My lord, I beg to mention admission matter, my lord. Admission, it's a disciplinary proceeding, my lord. That is Senate. It's a 2021 matter, my lord. Not 6, my lord. For listing, my lord.
1st week of March.
First week, already.
May I please, Your Lordship? Your Lordship, I beg to mention a writ petition to be listed tomorrow.
Why?
Lordship, despite having the required eligibility criteria, the petitioner's candidature was rejected. And recently, the petitioner could come to learn that on by a communication dated 30/8/2022, two private respondents who have been made part of this petition have been shortlisted. So, my lord, the post may be get filled any time soon.
Friday, motion day, Friday.
Much better.
Put the date of Friday.
Much better.
May I please lordship, I beg to mention item number 30 admission number. I'm on
Yes.
the behalf of HR Chaudhary. My lordship, my general counsel is out of station today.
Item number 38.
30.
What do you want?
Matter, pass over the date. But maybe 5th and 7th October.
Fix is not. On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks, list according.
I please the lordship beg to pray for listing of WPC 2688 of 2021. Can it be listed next week, lordship?
Why it should be listed? First of all, the court does not do the listing. Why, what is the urgency? You find out and come back. Mr. S.H. Mahmood, learned counsel for the petitioner, submits that he has instructions from his client to withdraw this petition. The prayer is not opposed by Mr. D. Bora, learned government of Assam, appearing for the respondent. In view of the above, this writ petition stands disposed upon withdrawal. Please.
For motion item 2.
May it please your lordship. And I was first appointed as the lordship. I was first appointed as the Anganwadi helper. Then I got upgraded to Anganwadi worker. I joined the service also. But at the same, suddenly there was an impugn notification at page number 23.
So you got suddenly upgraded,
No, your lordship.
and then they are suddenly downgrading you. What is wrong with it?
No, so suddenly the impugn notification was issued. Your lordship. Impugn notification was issued. Suddenly,
How
impugn
can,
notification.
how can someone be upgraded? This is either a promotion. Where is the order of promotion?
Page number 20, your lordship.
Page number 20.
Yes, your lordship.
Then where is the impugn?
Page number
My lord,
20.
One thing that I want to bring 23, my lord notice. My lord, this is of Chiram, BTC, transfer subject, my lord. So BTC is required and their name is not shown in the cause list.
No, your lordship, I have supplied your copy. Last.
All right, then we'll have it on Friday by showing the name of.
Their name has to be shown, my lord.
I have supplied your lordship the copy.
BTC,
It appears that this writ petition pertains to BTC administration, pertains to a decision taken by the BTC administration, and therefore this writ petition be listed again on Friday's date video by showing the name of learned standing counsel BTC in the corpus. Your furnished copy.
I have already published copy of license.
Item 3.
My lord, in this matter, I was supposed to bring instructions, my lord. In fact, my lord, I have received instructions, paraphrase comment, and I have prepared an affidavit also, my lord. I have served a copy. So today I am filing it, my lord, the affidavit. They can take any date, my lord.
Lordship, we have received the copy, but in the meanwhile, I would like to pray for an interim protection, Lordship.
My lord,
Lordship, we are permanent employees now, and we should be protected because we are being arbitrarily removed from our post.
my lord,
We are,
Please take your seat,
My-
Mr. Dhar. Let her. She is the petitioner's counsel. Yes, what is your case?
Lordship, there is a regularization order. Lordship, will find that order as page number 45, and extra 4.
Yes.
In this order, it is written that in pursuance of the order dated so-and-so in WPC number so-and-so, it is directed that the petitioner's service will be continued without disruption, and they will be treated as a permanent staff of the concerned advisory council. That is, their services will not be dependent on the tenure of the vice chairman of the council, and they be treated as essential staff in the office of the vice chairman of the respective councils. The order is passed in compliance of order dated so-and-so passed by the Guwahati High Court. Lordship, immediately thereafter, we were being asked not to come to the office. The passes that we had, which we used to enter the office, were not renewed. And they are saying that since the advisory council is not there, so we are not allowed there. Lordship, can it be done?
Just a minute. When was your appointment? How many petitioners are there?
Lordship, there are 5 petitioners.
Yes, when were you appointed? Where are the appointment orders?
Lordship may find it at page number 17. Lordship, there was a writ petition in this regard wherein we were.
Just a minute, just a minute. So this was pursuant to some selection process.
Yes, Lordship.
What was, when was the advertisement issued?
Lordship, I do not have the instructions. with regard to
Without that, how can you get? a-
Lordship, there is an order of the Honorable Guwahati High Court whereby, wherein we were asked to, wherein initially our services were co-terminus with the advisory council, but after that order of the High Court, we were made permanent staff. And they did not comply with it, so we even preferred a contempt petition. In the contempt petition, they
No,
brought this instruction.
you have to first answer the question of the court. Because this court will go by the legal principles. When was your appointment made and in terms of what process? That is the first thing we would like to know.
Lordship, I'll get the instructions tomorrow because I do not have exactly when it was, but
Then let him file affidavit. We'll have it day after tomorrow then. Miss A. Begum Learned
N.
Counsel, N. Begum Learned Counsel is present on behalf of the petitioner. Mr. R. Dhar Learned Standing Counsel, WPT and BC Department submits that on receipt of written instruction, he has prepared an affidavit and shall bring it on record during the course of the day. Full stop. Miss Begum, on the other hand, has expressed urgency in the matter and prays for an order of protection of the interest of her clients. Full stop. Be that as it may, since the Learned Departmental Council was earlier granted time to obtain instruction, and in view of the fact that instructions have not only been received, but he is proposing to bring the same on record in the form of an affidavit, this court is inclined to grant 2 days time to the Learned Departmental Council to do so. As such, in view of the urgency expressed by the petitioner's counsel, registry to list this case again day after tomorrow by tagging the affidavit with the record of the case if the same is filed within during the course of the day.
much okay.
Item 4.
Matter pertains to appointment of Anganwadi worker matter. Petitioner earlier participated in earlier selection process, my lord. As the appointment was not made, my lord, she approached this honorable court, my lord. And this court by order dated, my lord, 10/10/2000, by order 6/5/2020, my lord. Disposed the writ petition directing the respondent authorities to contact the selection, my lord, by issuing an advertisement, my lord.
So we'll issue notice. In this case. So, had Mr. A.H.M.R. Chaudhary Learned Counsel for the petitioner assigning the selection and appointment of respondent number 7 in the post of Anganwadi worker.
Worker, my lord, appointment has not been made, my
It's a
lord.
selection, she has been selected.
No, my lord.
Then?
Just interview was held, my lord.
And then you write alleging irregularities in the process adopted by the respondents for filling up a vacant post of Anganwadi worker under the Katlichara ICDS project. The instant writ petition has been submitted, has been filed inter alia contending that although the respondent number 7 is not even a resident of the areas coming under the ICDS project, yet her candidature has been accepted, as a result of which prejudice is likely to be caused to the interest of the petitioner.
And
That's
my
okay.
Petitioner's candidature was rejected, saying that he is outside of survey area, although he is inside within the revenue village, my lord.
Not within the villages coming within the purview of the ICDS project, full stop. On the other hand, a petitioner's candidature has been rejected, although she is a permanent resident of the local area, full stop. Mr. R. Dhar Lanet, you are for
My lord, addition of senior government advocate, my lord.
Learned addition senior government advocate Assam appearing for the respondents prays for some time to obtain instruction in the matter. NOM 66, since Mr. Dhar has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. No, not all the respondents.
There are private, my lord.
Respondent numbers 1 to 4.
1 to 4, my lord.
No formal notice is required to be sent in this case. Who are these respondent numbers 5 to?
My lord, they have appeared in the selection interview, my lord. Before interview, petitioner expenditure was rejected.
1 to 4. No formal notice is addressed. Extra copies requisite in numbers be furnished to the learned government advocate Assam. Petitioner to take steps for service notice upon the remaining respondents. And instant post with AD.
My lord, some interim prayer is there, my lord.
Prayer for interim relief will be considered on the returnable date.
Obliged.
Item 5.
May I proceed, please? Not earlier that instruction was called for, my lord.
Yes, what do you have to say? What is your instruction?
Your lordship.
Now, can you please speak up? What is the instruction?
Yes, lordship, the question was whether the degree, the HSLC and the Assam High Secondary Education Council degree by the Nagaland State Board is recognized or not. So as per my instruction goes, that is not recognized. As per the guidelines issued by the Social Welfare Department of 2019, the candidates
Not recognized by whom?
not recognized by the Social Welfare Department.
That can't be.
Because
We don't, this is hardly of any relevance whether who is social welfare department to
no,
recognize?
there is a problem. There is just one gray area here. It says that the candidate for the post of Anganwadi worker or the worker of the mini Anganwadi center should have the qualification of HS pass from the Assam High Secondary Education Council or its equivalent examination from a recognized board or council. Now that recognized by the government of Assam. Now that particular issue has to be, I have to seek instructions whether that falls under that criteria.
Then this matter will take time. We have to stall the process.
My
So
lord,
your lordship may grant me just 2 days time. I'll get the instruction whether this Nagaland High Secondary Education Council certificate is recognized by the government or something. If it is recognized, then it can be disposed of, your lordship.
my lord, kindly have a look at page 39, my lord.
We'll have it on Tuesday then. Next
Tuesday.
Tuesday. Heard Mr. N. Ahmed, learned counsel for the petitioner, also heard Mr. D. Bora, learned government advocate Assam appearing for the official respondents who submit that although he has received some instruction in the matter, yet 3 days further time is required to verify as to whether the educational qualification of the petitioner has been obtained from an institution under the government of Nagaland, which is recognized by the state government of Assam. Mr. Bora submits that the aforesaid instruction will facilitate early disposal of the writ petition.
We have already annexed a human research development in India, a letter, my lord, where it is recognized by the
All right. In view of the above, and on the request of Mr. Bora, this matter be listed again on 7/2/2022 as a fixed item for motion. You verify yourself,
Yes,
but
sir.
your government cannot recognize or de-recognize.
Yes.
So if you say that it is not recognizable, then also we'll pass the same order. If you say it is recognized, and if you say it is not recognized, same order will be passed.
Same.
Only thing is, we are putting on record that you are given time to
Yes.
address the court on
I
that.
just need one hard proof that this particular educational qualification is recognized by the government of Assam. In
It is
all probability, it should be recognized.
Yes. The social welfare department has no business recognizing degrees.
Yes.
That's not their job.
Yes.
displacement.
Item 6. Your lordship, as per your last order dated,
They have filed the affidavit
we
already.
have filed our affidavit, however, it's not on record, lordship.
They have filed the affidavit, only they have taken the ground is there. I am not diploma holder, I am a M.Tech, master degree. And they have said only that, he is energy engineering. But in that 5 years course, my lord, there is electrical engineering, energy engineering, and my lord, mechanical engineering. So mechanical engineer one of the qualifications.
So you have received a copy of the affidavit.
Yes.
Then would you like to file a rejoinder?
No need, man, because they have already said that in my rejection list, they have said not qualified.
All right, then let the affidavit be tagged with the record and it will be
Because
listed.
day after tomorrow, my lord, today, tomorrow, and day after tomorrow is the, my lord, interview date.
All right, call for the affidavit. We'll take it up after some time.
Apply.
Please ask your junior to give us slip.
And in other matter, my lord, similar matters, your lord should give interim order to allow them to appear at least. That what is there, my lord.
Item 7.
The affidavit is not called. May I please, your lordship? Lordship, this is compassionate appointment, my lord. My case is recommended by the DLC, my lord. Annexure 14, my lord, page. Your Annexure 2, my lord, page 14, my lord. Relevant portion is, my lord, page 16, my lord. DLC recommended my case, my lord. Lordship, impugned order is, my lord, Annexure 5, my lord. These issues are not covered by the judgments, earlier judgments. Yes, my lord, my case is covered by the judgment, my lord. Covered means it goes against your client's interest. You may not be aware. See, what happens is you may get an order from this court or that court. But what you are actually doing is drafting a contempt petition, which will be closed after 2 years. All right. You may not be bothered about it, but as judges, we have to be conscious. You are not even aware, or even if you are aware, you just want to file this petition and take a chance. These petitions filed after years. There is a government circular, division bench judgment that it cannot be entertained. Yet, I am conscious that some of the honorable judges are passing orders for disposal, but then what relief do you get? Ultimately, the government will go by whatever is the settled law. Yes, is this case permissible?
No, your lordship, because
Why not?
Supreme Court judgment is the state of Manipur versus Rajauddin, 2003.
Where is the judgment? Sure.
I don't have it right now. If your
Then
lordship,
when will you have it?
after some time, if your lordship. will-
Yes, after 20 minutes. Yes.
Item 8.
May I please, your lordship? This is also compassionate appointment, my lord. Here, my lord, DLC recommended my case, my lord. SLC rejected on the ground, on the two ground, my lord. Page 25, my lord. Impugned order, my lord. Relevant. No, all right. What we'll do is we'll issue notice in both of them. Yes. In item 7 also, you write, heard Mr. H.L. Ashkar. H.L. Ashkar are counsel for the petitioner. The petitioner is aggrieved by non-consideration of his prayer for appointment on compassionate ground. Full stop. According to Mr. Lashkar, the prayer of the petitioner has been rejected in an arbitrary manner, resulting into serious prejudice to the interest of his client. Full stop. Mr. D. Bora, learned Government Advocate Assam, appearing for the respondent numbers in item 7.
In item number 7, respond numbers. Lordship, 1, 2, 3, and 4. All the respondents.
Appearing for the respondents, praise for 4 weeks time to obtain instruction. Prayer allowed. NOM 4 weeks. Since Mr. Gora has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned department, learned government advocate as well, so as to enable him to obtain instruction. Facilitating disposal of the writ petition at this stage of admission hearing. Stop. Our next to 1 to 5, all the respondents. Okay, same order.
And no, in item number 8, I'm appearing only for 4 and 5.
And who is for the other respondents?
PWD sending out, so Mr. Ardhar can appear, he was here.
Mr. Ardhar for respond numbers 1, 2, and 3, and Mr. D. Bora, learned government advocate Assam for 4 and 5. Item 8 of it, no? Baki ek rahegi. Right, Prabhat.
Item 9.
Good morning, my lordship. May I please your lordship? My lord, this matter today's decision is relating to the appointment of Kaubura of lot number 2, Bornoti, under Paschim Nalbari Avenue Village, circle of Nalbari Circle. Actually, the brief of the fact of the case is that the petitioner is the son of deceased Kaubura, Kaupradhan, late Nipendaka. The petitioner was helping of Kaupradhan of village Bornoti, lot number 2, under Paschim Nalbari Revenue Circle of Nalbari district. During the tenure of his service, late Nipendaka, father of deceased petitioner, was suffering from illness and he was not fit for perform his duty well. So, on 7/12/2018, let me
Open instruction will issue notice.
Otherwise, logic, para 9, he himself stated that he has not attained the age of 30 years from the date of advertisement. So he does not call for interview, that's why.
But
Otherwise, logic.
Nipendaka, petitioner Nipendaka was servicing since 4 years long, according to permission of circle officer and concerned authority. And at that time, age limit was
Very
25
strong
years.
case, notice. Yes, your name
Otherwise,
please.
that is division benches, certainly.
All right, your name please.
My
Yes.
my name is
Apna naam sir.
my name is Mapani Burman, M. Burman.
Heard Ms. M. Bormal, learned counsel for the
Mrs.
petitioner.
M. Burman.
There is the amendments made in the writ petition. The petitioner is aggrieved by non-consideration of his candidature for appointment as a Gaugura. Responding to the allegations made in the writ petition, Mr. S. Datta and his standing counsel Revenue and Disaster Management Department Assam submits that the petitioner in all probability was underaged, but in order to conclusively address the issues raised in the writ petition, the learned department of council prays for 4 weeks time to obtain instruction. Prayer allowed. Issue notice of motion returnable in 4 weeks. Therefore,
Number 1, 2, and 3.
since Mr. Datta has appeared and accepted notice for respond numbers 1, 2, and 3, and Mr. Axis Roy,
4, 5, and 6.
Government Advocate Assam for respond numbers 4, 5, and 6. No formal notice is required to be sent to the said respondent. Extra copies will be furnished to the learned department council. Petitioner to take steps for service of notice upon respond numbers 7 to 11 by registered trade within a week from today. Yes.
My lord, again,
Appointment, if any, made to the post of Gaugura shall be subject to the outcome of the writ petition.
obliged, my lord. Obliged. Item 10.
May I please, your lordship? My lord, this is regarding compassionate appointment, my lord. My case has been considered by the DLC, my lord, page number 11, my lord. In grade
The
4.
matter
post.
pertains to prayer for appointment on compassionate grounds. It appears that the case of the petitioners, how many petitioners?
3 petitioners.
3 petitioners were considered and recommended by the DLC, but the SLC had rejected.
No SLC has been placed.
But till date, the same has not been considered by the SLC, as a result of which this writ petition has been filed. Heard Mr.
FL Ashkom.
F.A. Lashkar, learned counsel for the petitioner, Mr. S. Roy, S.S. Roy, learned government advocate Assam placed for some time to obtain instruction in the matter. In view of the above, NOM 6 weeks since Mr. Roy, since Miss
Yes, new for.
Yes, new. Learned SC Irrigation Department Assam has appeared and accepted notice on behalf of respondent number 1,
1 and 3,
1 and 3, and Mr. S.S. Roy, and government advocate Assam.
2 and 4.
2 and 4 service of notice will deemed to be complete in this case. Extra copies, yes, facilitating disposal. It will be. Obligement.
Here the allegation is that the proceedings were conducted ex parte behind the back of the.
So there is already some
WPC 360 of 2023.
WBC 360 of 2023. What is the date of the order?
Mother, that is of 31/2023.
I mean, let's see the book. Suppose no date of it. Give the same order.
The
List along
Enquiry report is also of the same date, 28/4.
inquiry report of date 28. Same order. List along with AW. Yes.
Obliged.
Yes.
May I please? Your Lordship?
Yes, yes.
My lord, this is a matter relates to selection and appointment of a Gaon Pradhan, my lord.
Hmm.
My lord, an advertisement has been issued. My lord, may be pleased to find the advertisement is at page 53.
What is the point? Tell
My
the
lord,
point.
point is that the person concerned is required to be a permanent resident of the particular charge of the village area, my lord.
Hmm.
But the person, the private respondent who had been selected, my lord, till date no appointment has yet been offered is from not within the jurisdiction of that charge, my lord. Apparent on the record, my lord.
Similar to the earlier case, also he has not fulfilled the age criteria. He is only 24 years as per his affidavit.
So
Page
it's for
29.
24 years out.
My lord, in that case also, my lord, there is already an order passed by this honorable court directing the commissioner, my lord, to take a decision as regards my age in the attending facts and circumstances, my lord. Till date, my lord, they have not, my lord, taken up the issue, my lord, and still it is in the pending.
No,
But on the other hand, my lord, they have proceeded with the, my lord, this selection process. my
Yeah,
lord.
there is no question of taking any decision,
My
Mr.
lord.
Once you are underage, you should be 30 years, you are 24 years. What is the decision that is to be taken?
No, my lord, in certain cases, my lord, the commissioner has, my lord, taken a decision, my lord, allowing such persons, my lord, as per my instruction, my lord,
Hmm.
that they allowing such person to participate. Earlier, it was, my
Where,
lord,
sure.
no, my lord, that is relevant document, my lord, I have not annexed today, my lord. My lord, can it be taken?
How much time you want to annex that document?
Already taken. Government has taken decision. So no, all of them.
No, my lord, in my case, my lord, may kindly see the order passed by this honorable court, my lord. My lord, may kindly peruse the order, my lord. My lord, may kindly turn to page 67, my lord.
Hmm.
The operative part, my lord, may be pleased to find is at page, my lord, 69. Paragraph 3, my lord, at page 68 starts from the petitioner in this writ petition assailed the notification dated, my lord, 26/8/2021, providing the minimum age of the Gaonburas to be 30 years. But we have noticed that in the earlier writ petition being WPC, an issue had arisen, and that on the other hand, the notification of 2019 provided that the minimum age of a Gaonbura had been brought down from 35 to 25 years. Whereas the subsequent notification of the year 2021 provided the minimum age has been brought down again from 35 years to 30 years. Therefore, a question had arisen that if in the year 2019 it was brought down to 25 years, in the 2021, it could not have been brought down from 35 to 30 years. Accordingly, there was a direction to the Commissioner and Secretary Government of Assam in the Revenue and Disaster Management Department to take a decision on the same. We are of the view that the issue raised in this writ petition would be covered by the same direction as passed in so and so, requiring the Commissioner and Secretary Management Department to take a decision in the matter. Accordingly, the grievance of the writ petitioner in this writ petition regarding the minimum age for the post of the Gaonbura shall also be governed by any such decision that the Commissioner and Secretary Management Department may take.
Hmm.
It's
My lord.
So
They
he's
are
saying
not-
the decision has been
Is
taken.
it taken, brother? 27/10/2022, department has taken decision.
Lord, we have not been communicated.
Already
with
notified, Lordship.
any such decision, my lord. If
27.
my lord. Dangerous, my lord, for me, my lord.
Hmm?
Again, I have to challenge that also, my
Yes.
lord.
Hmm.
My lord. Huh? ইমান কম বয়সত 18 বছৰ পৰা দেখোন গভৰ্ণমেণ্ট চাকৰি কৰে।
Tell him to wait
Run.
for some
Yes.
2-3 years, 4 years more.
My lord, গাঁও প্ৰধান is nowadays in very tender age people can become গাঁও বুঢ়া, my lord.
Now-
In
now
the
it is
earlier
গাঁও-
days, my lord,
Now it is now.
গাঁও প্ৰধান, my lord. They have upgraded the, my lord, terminology, my lord.
Balance কৰিব লাগিব।
No, where is the relevant part? Just point out which page. This is 27 October 2022.
Yes, yes, that is.
After this. Yeah.
So you challenge this
Hello.
notification. You want to
Okay.
withdraw?
Lord, I no option left, my lord.
Yes. Heard Mr. A.R. Bhuya, Learned Counsel for the writ petitioner. Also heard Mr. S. Dr. Learned Standing Counsel, Revenue and Disaster Management Department, Assam, who submits that after the order dated 29/9/2022 was passed by the Learned Sangil Judge in WPC number 6577/2022, the government of Assam has issued necessary clarification in the form of corrigendum, which was published in the Assam State Gazette on 27/10/2022. Full stop. In view of the above, there can be no doubt about the fact that the petitioner was underaged on the date of the advertisement, and therefore he cannot have any locus standi to maintain this writ petition, questioning the selection process pertaining to the other candidates for appointment as Gaon Pradhan.
গাঁও
First
প্ৰধান।
up. After examining the notification, Mr. Bhuya seeks leave of this court to withdraw this writ petition with liberty to file appropriate proceedings, assailing the decision of the government. Prayer allowed, list according. Prayer allowed, writ petition stands disposed.
Copy can kindly be given to.
Give him a copy.
Oblige কৰিব। কপি এটা লৈ ল'বা।
Item 30.
May it please your lordship. Lordship, I am aggrieved by my non-consideration for promotion to the post of superintendent in the family court at Guwahati, my lord. My lord, I am a stenographer. I do not belong to the ministerial cadre otherwise, my lord. But as per the Shakti Commission's recommendations, switch over from stenographer to ministerial cadre has been permitted, my lord. In the draft rules also, there is a provision. Draft rules, if it's a stenographer.
Mr. Das, you need to take instruction.
Yes, my lord.
So we'll issue a short notice, 3
Right.
weeks, Heard
Right.
Mr. P.D. Nair, Learned Counsel appearing for the petitioner. The petitioner is aggrieved by non-consideration of her case for promotion to the next higher rank of,
My lord, superintendent family court.
next higher rank, which is the post of superintendent of, in the family court at Guwahati. Family court at Kamrup, Guwahati. Post of. According to Mr. Nair, his client is presently serving as
Stenographer grade 1.
stenographer grade 1 and is the senior most person in the
Establishment.
full stop. Notwithstanding the fact that the rules do contemplate consideration of our case for promotion to the next higher rank, no effective steps have been taken in the matter till date. Full stop. Being aggrieved thereby, this writ petition has been filed. Stop. Mr. H.K. Das, Learned Standing Counsel, GHC, appearing for the respondent numbers 345, and Mr. S.S. Roy, Learned Government Advocate, Assam, appearing for respondent numbers 1, 2, and 3, have prayed for 1 and 2, have prayed for some time to seek instruction. Full stop. Issue notice of motion returnable in 3 weeks. Since Mr. Roy has accepted notice for respondent numbers 1 and 2, and Mr. Das for respondent numbers 3 to 5, service of notice is deemed to be complete in this case. Extra copy of the writ petition will be furnished to the Learned Department Council within 3 days from today, so as to enable them to obtain instruction and file affidavit. Stop. It is made clear that pendency of this writ petition shall not be a bar for the authorities to consider the case of the petitioner for promotion in accordance with law, if so advised.
Deeply obliged. Much obliged.
May I please your lordship? Lordship, the petitioner has agreed by the action on the part of the authorities in incorporating the name of the respondent number 5 in the list, my lord, which is at page 23, my lord. Her name has been placed as serial number 1, my lord, although she is not a resident of the within the survey area of the Anganwadi center, my lord.
We'll have to issue notice only. What else? Notice,
They can take instructions, my lord, by the next week, my lord.
instruction. You obtain instruction.
Till then, my lord,
Till then, nothing.
till then,
You wait.
they will maintain
Nothing will
status quo, my
happen.
lord, because no appointment has been made.
I heard Mr. D. Kalita, learned counsel for the petitioner. Peruse the amendments made in the writ petition. The petitioner is an applicant for appointment in the post of Anganwadi worker in respect of number 140 Singimari PT-Roman capital 2 Anganwadi Center. Full stop. She is aggrieved by inclusion of the name of respondent number 5 in the list of eligible candidates for appointment to the said post on the ground that the said respondent is not a resident within the survey area coming under the AWC. Full stop. Mr. C.S. Hazarika, learned government advocate, Assam, prays for a week's time to obtain instruction and respond to the allegation made in the writ petition.
Some time protection, my lord.
Let this writ petition be listed for motion again after a week. In the meantime, the learned government advocate Assam to obtain written instruction and place it before the court. 2 extra copies of the writ petition be furnished to Mr. Hazarika during the course of the day. What interim protection?
But because no appointment has been done, my lord,
No, if appointments will happen, we won't have the power.
my lord, we will definitely.
All right, then wait. Yes.
Obliged, my lord.
Item 15.
The petitioner is serving in the ICDS project Kalaigaon
Hmm.
as a supervisor. My lord, on an earlier occasion, he and his wife had approached this honorable court regarding the transfer, my lord. When the petitioner had paid for a transfer to a posting near his wife's location because he had to travel around 300 kilometers every day, the respondents had transferred his wife to his place of posting. Challenging both, my lord, they had approached this honorable court. Lordship would find the order at page 35. Relevant portion, my lord, at page 36, paragraph 4. There was a direction for them to consider the representation made by the wife to retain her at her place of posting. And the petitioner forgot his representation for a posting to a posting near his wife's place of work, my lord. That lordship would find it page 37. Page 36, paragraph 4, my lord, where the representation of the wife was required to be considered.
Just a minute, just a minute. Where is your representation dated 26/12/2022? Which page?
And my lord, that lordship would have at page 44, my lord. Number of the post to which I pray is at present lying vacant because the incumbent therein has been transferred out. That lordship would find at page 43.
Just a minute, Mr. Majumdar.
My lord.
So wife is presently at Borpeta.
No, my state Borpeta, she works at Jolo. I'm at Kolaigaon, which is around up and down distance from Borpeta is around 300 kilometers. We had therefore made a prayer that we can both be retained at Jolo, where I can take care of the family. On the earlier order of litigation, I gave up my right for my prayers for the financial year or the calendar. My wife was retained. Now, my lord, the post which I had prayed for is lying vacant at Jolo. That lordship will find at page 43. Now, in case they want to fill up that post,
Who is the authority to issue the transfer order?
the authority is the respondent number 2, my lord, Joint Director comes CHD, Women and Child Welfare Development, DPC Kokrajhar.
Yes, who is appearing for respondent number 2? Why don't you consider?
Lordship will consider that.
Huh?
Lordship will disclose this matter, Lordship. Prayer number 2, Lordship.
Prayer number 2.
Yes.
Should I dispose it today or you want to obtain instruction?
Granting us 15 days time or 15 days time, Lordship.
Take down. Heard Mr. R. Majumdar, learned counsel, appearing for the writ petitioner. Full stop. The petitioner hearing is presently working as UDA accountant and posted in the Kalaigaon, KALAI, ICDS project in the district of Udalguri. Full stop. The wife of the petitioner is also a government servant and is presently posted as a supervisor in the Jala JALH ICDS project, Baksa, full stop. Due to the family reasons and more particularly the upbringing of their 9-year-old son, the wife of the petitioner is compelled to reside at Barpeta, and from there she is attending her official duties at Jala ICDS project, full stop. Since the petitioner is posted at Kalaigaon in Udalguri district, he is required to travel more than 300 kilometers each time. Each time there is a need to stay with his family, full stop. According to Mr. Majumdar, the post of according to Mr. Majumdar, the separation of the petitioner from his wife and children is not only causing immense mental agony to his client, but the distance of travel is also such that the same is posing extreme hardship to his client. Full stop. Mr. Majumdar submits that the post of UDA cum accountant in the Jala ICDS project has recently fallen vacant. Full stop. Therefore, there is a scope for the authorities to transfer and post the petitioner in the Jala ICDS project as UDA cum accountant. Full stop. If the same is done, the petitioner will get an opportunity to stay with his family and look after his son. Full stop. As such, on 26/12/2022, the petitioner had submitted a representation before the respondent number 2 by narrating the background of the case with a prayer to transfer him to Jala ICDS project. Full stop. The grievance of the petitioner is that till today, his representation has not been considered by the authorities. Full stop. Mr. P. Nayak, Learned Standing Council BTC, appearing for the respondent number 2, submits that the prayer of the petitioner can be considered by the authorities if some time is granted by this court. Full stop. In view of the Mr. C.S. Hazarika, Learned Government, you are there? Achha. You are for all the respondents?
Yes, sir.
P. Nayak, Learned Standing Council BTC, appearing for the respondent, submits that the representation dated 26/12/2022 submitted by the petitioner can be considered by the competent authority if some time is granted by this court. If that be so, there is no justifiable reason for this court to keep the matter pending before this court. Full stop. I, therefore, dispose of this writ petition with a direction upon the respondents, more particularly the respondent number 2, to consider the representation dated 26/12/2022 submitted by the petitioner sympathetically, and unless there is any legal hurdle coming in the way of his transfer to ICDS Jala, appropriate order may be passed in the matter, keeping in mind the facts and circumstances of the case. The aforesaid exercise will be carried out and completed within 3 weeks from today. Within 3 weeks from the date of receipt of a certified copy of this order, till such time the vacant post of UDA cum accountant in ICDS Jala shall not be filled up.
Just one observation, Lord. This is an application of 26/12. Today is the 1st of February, Lord. So already 1 month has gone. Possible, just pass one observation. If not, if already this has been disposed of, Lord, that will be informed to the petitioner. And second, Lord, keeping that post vacant, Lord.
If the same has not been filled up already. Stop. That's all. Writ petition stands disposed of. If it has not been filled up, if it has been disposed of, it has been disposed of.
Not, only one observation. Jala or any other ICDS project in
Jala,
Jala would also do. Any project in
Jala, it will also be open for the authorities to consider consider whether the petitioner can be transferred to any other nearby ICDS project so as to enable him to reside with his family.
No, placement.
Reside, live with his family, live with his.
Petitioner before your lordship retired as a 4th grade casual worker from the office of the district fishery development officer Dorong Mongol with fixed pay. During her service, Division Bench of Honorable High Court made a direction to the state government to provide minimum pay scale. And in this regard, district fishery development officer made a letter to the director of fishery.
So here notice has to go.
Lordship.
Will issue notice? I heard Mr.
K. Rahman,
Learned Counsel appearing for the petitioner. The writ petitioner hearing was originally engaged as a grade 4 casual worker on a fixed pay in the year 1986, and since then he has been continuously rendering his services under the department. Full stop. The pay of the petitioner has also been raised to rupees 9,000 per month. However, till today, the petitioner has not been granted the minimum scale of pay. Hence, this writ petition. On perusing the amendments made in the petition, I am of the view that the matter would call for further examination. Stop. Issue notice of motion returnable in 6 weeks, since Mr. C.S. Hazarika, Learned Government Advocate Assam, has appeared and accepted notice for respondent numbers 1, 3, 4 and 5, and Mr. P. Nayak, Leonard, SC Finance Department, Government of Assam, for respond number 2. Service of notice is deemed to be complete in this case. Extra copies of the requisition be furnished to the Learned Department Council so as to enable them to obtain instruction in the matter.
Well, pendency may not bar to redress the return. Obliged.
Item 17.
May I please, Your Lordship? Lordship, here, my lord, the petitioner is serving as a office cum field assistant contractual, my lord, since more than 8 years, my lord. Since 2011, my lord.
So what is your prayer?
My prayer is, my lord, there has been a similar set of cases has been disposed, my lord. Because an advertisement was released, my lord, for regularization, and when exam was conducted, my lord, he was not allowed.
Which page is the order? Similar order?
Order starts from, my lord, page number 28, my lord.
Who is for the department? Is it covered under this?
My lord, let us obtain instructions in this matter. My lords may issue notice. We'll have to verify if it's similarly placed in the matter.
The latest order is page 52, my lord. Since they are not completed 10 years, my lord.
We are taking a suitable economic package, my lord.
Economic package has been granted, my lord.
Therefore, we'll have to verify if we.
Then we'll keep it in motion only.
My lord, very well.
How much time you? Mr. P.K. Borderell, Learned Counsel for the petitioner, submits that the case of his client is covered by similar orders passed earlier by this court, and therefore his writ petition will be disposed of accordingly. Mr.
A. Borua, my lord.
A. Borua, Learned Counsel, appearing for on behalf of the APDCL authorities, placed for 2 weeks' time to obtain, to verify and obtain instruction in the matter, facilitating disposal of the writ petition. In view of the above, let this writ petition be listed for motion again after 2 weeks. 2 extra copies of the writ petition be furnished to Mr. Borua so as to enable him to obtain instruction. We'll close it if it is covered.
Very well, my lord. I'm obliged.
Item 18.
May I please, Your Lordship? It's a matter regarding promotional post of Anganwadi helper to work on Lordship. Petitioner is the only candidate of said post, Lordship. Also, Lordship, according to advertisement copy, advertisement, every criteria is fulfilled, but she was not selected. Lordship. Still, it is pending. And also, Lordship, she is working as now in charge of Anganwadi worker. Advertisement copy, Lordship, page 10. Lordship.
No, she was not selected in which DPC?
Lordship, Barnarpur, Kashiapundi.
Which DPC?
I see. Lala is.
All right, you want time for instruction. You want to further, you are not being able to understand the question of the court.
Lala ICP project.
I am asking you in which DPC your client's case was considered for promotion but not granted. That's the statement you have made. All right, heard Mr. H. Alamgir, Learned Counsel for the petitioner, peruse the amendments made in the petition. The petitioner is aggrieved by non-consideration of her case for promotion. Mr. C.S. Hazarika, Learned Government Advocate Assam, prays for some time to obtain instruction in the matter. Issue notice of motion returnable in 6 weeks. Since Mr. Hazarika has appeared in accepted notice for all the respondents, no formal notice is required for signing this case. The extra copy of the petition will furnished to the Learned Department. Please.
Item 19.
Yes.
It is for quashing of a department of proceedings, page 17, my lord. I was absent for 17 in 2016, and proceeding was drawn up 22, my lord. That is your page 17, my lord.
Departmental proceeding quashed.
Yes.
On what ground?
Ground is this matter, I have already resigned from service by in the month of March 2022. Thereafter, my position was drawn up. As drawn up my only basis that I absent in 2016 for 7 days. And position was drawn to 22 million. It was a page 17 million. It was really clear. Before that, I have resigned from service. Application but not granted.
Your resignation was accepted when?
Not accepted.
Not accepted.
Not accepted.
Then resignation has to be accepted.
Not yet. I have not, that is not done. I have not received any letter from the department.
Then
My lord, my submission is this, my lord. There, I was absent in 2016. Position was drawn up 22. That also, my lord, I have resigned from service because my lord, my mother is there. My old mother is there. I have to look after my mother.
Mr. Mohammed, you know what is the question. If you don't have an answer, say that I don't have an answer.
Yes.
If you don't want to give an answer, then also say that.
Yes.
There is no point deflecting here and there. Is it not?
Yes.
I am asking you, has your resignation been accepted?
I have received no letter from the department.
Correct. So therefore, resignation plea will not work out.
Parliament is not accepted because he told me. No, my lord, before my lord, till today, I have not received any letter.
All right. Had Mr. and Mohammed Learned Council, SK and Mohammed Learned Council for the petitioner. By filing this petition, the petitioner is approached this court with a prayer to quash the disciplinary proceeding initiated against him by order dated 1/11/2022. Full stop. According to Mr. Mohammed, his client had submitted resignation from service in the year 2016, and therefore the authorities could not have initiated the disciplinary proceeding more than 4 years after his resignation. Mr. C.S. Hazarika, Learned Government Advocate, Assam Praise for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Hazarika has accepted notice for the respondent, no formal notice, extra copies. So please give him the extra copy.
Yes, yes.
But you don't have a case. You know it. It's all right.
Yes,
It's all right. You don't have a case.
only my prayer is maybe only my mother is there, that too, she's very old mother. There is none to look at.
What has happened to the 4 lakhs?
My lord.
What happened to the 4 lakhs connected by your client? That is also a problem.
No, that is, but regarding 4 lakh that I have returned, that is not as a providing service matter, it is from loan matter. And he has also given letter, I have annexed here matter. There is no case or anything against me, my lord.
All
Till
right.
today.
All right.
Item 20.
May I please, Lordship? My lord, the case of the petitioner for compassionate appointment has been rejected, my lord, by impugn minus dated 5/8/2017, my lord. Page.
Well, I only notice at this stage, had Mr. B. Prakash, the Learned Counsel for the petition, agreed by rejection of his prayer for appointment on compassionate ground. The instant writ petition has been filed seeking a writ of mandamus. Miss
A.
A.
Talukdar
Talukdar,
for
Learned,
2 and 3.
Learned, you are standing counsel,
No lordship, government advocate for
Learned government.
SSC and DLC.
Government Advocate Assam appears and accepts notice on their, appears in place for some time to obtain instruction. NOM 6 weeks since Ms. Talukdar has appeared and accepted notice on their respondent numbers 2 and 3, and Mr.
A. Bura, my lord, for the PhD department.
A. Burwa, Learned Standing Counsel, PhD Department, has accepted notice for respondent numbers 1, 4, 5, and 6. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Department Council so as to enable them to obtain instruction in the matter.
May it please your lordship. Well, the matter relates to the chief engineer's promotion, where lordship had directed the production of the reports. My lord, and your lordship has specified that the respondent council will give us a copy of the minutes for the simple reason that my gradation list was brought down. There was no reason, and the benefit of the OM was supposed to be given. But on the day when vacating application was filed, the additional advocate general makes a submission that the OM of 18 is not applicable because it's a selection post. Merit with due regard to seniority. It's a selection post, and so the OM doesn't come in. If the OM doesn't come in, how could the person who was heard, he takes over as chief engineer. This is the information just now I get from my client. In their enthusiasm, they don't wait for your judicial scrutiny. He takes over charge yesterday evening, and he mentions that subject to outcome, means they know that it's under judicial scrutiny, subject to 405. Well, 450 is gone. 405 has merged with 499. And what I pray, Lordship, the records may be placed, because my case hinges on how I was downgraded, because the stand of the state government is now contradictory. They say that the OM is not applicable for you, because Lordship knows I get on merit in terms of RK Sabharwal. If this submission of the learned advocate general is there, well, it's in violation. Then if the person has taken over, Lordship can very well pass status quo ante order. In fact, I'll press for a status quo ante order and an expeditious hearing. This is a very serious case, for the simple reason that the government is brazenly taking over the authority. First of all, the OM is already under challenge. Well, the respondents will take the benefit. I have nothing to say about the respondents who got the benefit now. But I have been downgraded. I don't know. And the additional advocate general says, no, it is not as per the OM. I say it is as per the OM. This is a very serious case. And in their enthusiasm, possibly they thought that the judicial power can also restore it back. He sits and makes a submission. It is subject to final outcome of WPC, the first case. The first case is gone. In fact, when copy was given on 38, the council informed the government, we took their signature, and 499 was a new case. Lordship will not allow this sort of brazenness. This is a brazen executive brazenness. In fact, the council, my learned friend, I repeatedly asked him for the buy note because I wanted the Lordship to give a judicial order. But he basically says the government will not give you copy. The government will give it in a seal cover. Well, after SP Gupta, what is this? It's a concept of open government. The RTA is there. And my seniority goes down from first, I go to third, and I'm chased out now. So what I pray, Lordship will examine the minutes. But one thing is there, I stick to my point. It's a selection post. On merit, I go as an unreserved, settled position of law as per RK Sabharwal, it need not need. And the OM, they have applied the OM to bring me down, because first they have to bring me down. So that's the reason, Lordship.
Once you finish, we will have some discussions on the matter.
Yes.
Are you finished?
Yes, I finished.
Was your client considered for filling up the post of
Yes.
chief engineer as per these requirement of
Yes.
service rule?
Yes.
Yes.
That will be the subject matter of the minutes.
All right. So the criteria for selection is merit, correct?
With due regard to seniority. Yes,
All right.
Bala. This is we came to know today. The amendments are there.
So
All
the-
engineering departments are perimeter. It is same. It is merit with today. Somehow could collect the irrigation, but we have got it in our. It is merit with the 13.4. Promotion shall be on the basis of merit with due regard to seniority in all cadres and posts.
There
In
is
fact,
some,
this amendment was not there in the book which I referred. This was a book which talks about merit. On that, I made a submission. Possibly this amendment was brought in 1991. And all these are all parameter, PWD, irrigation, everything. 13.4, even that is the three departments have the same rule. In fact, the parent department was a PWD which had the rules. In the 81 rule, this was not there. The seniority comes in later. The irrigation also has seniority. The water resources also, just now I got it. So it's my duty to place
So two posts of chief engineer has been
Yes,
filled
one
up.
is chief engineer,
Quality control.
and other is chief engineer quality control.
Hmm.
And chief engineer, the normal post of chief engineer is being held by reserve category person.
On
And
merit.
now our client has been now promoted following retirement of Mr. Borthakur because he could,
So who is now holding the post of chief engineer quality?
Mr. Goswami, my lord, for whom I am representing. He took over charge yesterday.
And who is the chief engineer, main chief engineer?
Main chief engineer, he is a reserve category person, some Borsing Rongpi.
What was his position in the reserve? In the
My lord,
gradation?
no, my lord, he got the benefit of everything, but then he was stolen a marks before the general category could catch him up. So therefore, my lord, he has for all time to run.
No, just a minute. Just a minute.
He went by merit, lordship. He got by merit. His promotion was on merit.
Who?
Because earlier
My lord,
the engineer was my
let-
client. I appeared for him. He got by merit. There's a order judgment also of this court. Case.
No, this person, respond number 7, he has retired from service.
Yes, and I'm not against 7. 7 is already retired.
So-
Yesterday he has returned.
Okay,
And,
8 is,
Eight has been promoted yesterday. I have taken over charge yesterday.
and what about the other person? When was he appointed as?
My lord, I'll give the facts, my lord. My lord, right to be considered for promotion is a right.
No, Mr. Chaudhary,
I'm
we'll
coming
come
to
to
it.
those things.
Yes.
I want the facts.
Yes. Facts
Who
is, my
is
lord,
now
three-
holding the post of?
three persons were considered in the DPC, which was held on 28.
Hmm.
My learned friend's client, respondent number 8, whom I am representing, and respondent number 7, who retired yesterday.
Right.
So, my lord, this three were-
Considered for filling up how many posts?
one post of chief engineer quality control.
Right.
And my lord, first nominee was respondent number 7, and second nominee is respondent number 8, whom we represent.
Mhm.
And his case was also considered. On merit, he could not make it. My lord, the marks are like this. I think out of I got something about 20 and odd, and he got 15 or 16. And my lord, whether it is merit cum seniority, whether it is merit with due regard to seniority, these are all merit-based, my lord, criteria. In other words, if merit is higher, then my lord, the person will steal a marks. No, of course, my lord, others in the zone of consideration, their cases will also be considered. Now, he cannot have any grievance for the present because, my lord, he was in the zone of consideration. Even if there was any alteration of the seniority by applying the, OM of 18,123, even then he has not suffered any prejudice because he is within the zone. And now he will have to satisfy your lordships that selection was there. Other than that, he has got no option.
That's correct.
If he succeeds in establishing that the selection was bad, then he has a
But
case.
is one matter fixed today where the records have been called for? Is
I
it-
think this is the matter along with item number 41.
Because on the first occasion I came on 40 and records were called for.
So therefore, my humble submission is, my lord, my learned friend cannot have any grievance regarding seniority because he is within the zone of consideration. His case was considered. Because of less merit, my lord, he was not selected. Person with higher merit was selected. Now you have to satisfy, yes, this selection is bad on account of XYZ. Then he may have a case. Otherwise, my lord, this petition, nothing, no live issue survives. Other than that.
And the chief engineer post which is held by the other person.
Yes.
70.
He was appointed earlier.
Yes.
He is not a part of this.
No, he is not one. Because as I said, my lord, by the time he became chief engineer, he has already, my lord, overtaken his general category where otherwise senior. In fact, my lord, last almost 20 years in the all the works department of the government of Assam, I don't think any general category candidate has reached this stage of chief engineer secretary because of this consequential seniority business.
All right, we'll take up item 41 when it reaches.
My
But this we'll see because the records have been produced.
Yes.
Yes,
But I
so,
may be given during the independent copy to just go through the.
yes. So here, Mr. Das, what you have to say? What
Well,
else?
Madam, my view was-
Unfortunately or fortunately, whatever, we don't know. What Mr. Chaudhary is saying, that's the position in law.
subject to what I find from the minutes, because
No,
your
minutes-
lordships in the lordship's order, your lordship will say that I need to figure out whether due consideration was there.
No, that will go into in the other matter,
Yes,
right? But in this case,
yes.
you have already, your basic grievance is downgrading.
My basic grievance is not downgrading in violation of the rules. That your lordship will have to give a finding.
Mr. Das, please.
Yes,
Don't
yes.
be excited. We
Yes,
understand there are issues, but let us try to, there are
Yes,
finesse
yeah, I'm
into this.
interacting only. I'm interacting with the
You
board.
see, there are two aspects here.
Yes,
You please tell me what is yours.
my stand is that.
First, listen to what is the
Yes.
query. There are two aspects of the matter.
Yes,
The first aspect is where you initially came to the court
yes,
saying that by taking advantage of a OM, which in a way has some offending clauses, the benefit of accelerated seniority is being sought to be denied.
no,
Right?
no, that was not my case. That was my case in the Lanthasa, where the constitutional validity. Here I
All right,
never
so you
said,
are aggrieved by downgrading of your client.
in violation of the rules. That was
Correct.
my case.
So downgrading on its own may have another facet. That is a matter which will be decided in that writ petition. But for an immediate consequential, relief, that the downgrading will take your client out of the zone of consideration for selection of the post of chief engineer. There, the matter was projected that even if he is downgraded, he will be considered, and this selection is purely on merit. That was the submission of the government council. The court took note of the submission and permitted them to go ahead with a rider that don't notify. The next day, an application was moved saying that one of the candidates is retiring on 31st.
Yes.
And 31st is a holiday. So if this order is not modified, then even if he is selected, he will be all times
Yes.
deprived.
Yes,
So taking note of that, the court
Modified.
granted them the liberty to.
absolutely, absolutely.
The
Correct.
fact of the matter remains that out of the three candidates, your client was one of them. They had considered the case of all three and found that your client is the third in order of merit. Rightly or wrongly, that is their finding.
In violation of the rules.
So you have to challenge the proceedings.
I've already challenged it, but unless I get a copy. So what I personally feel, a copy may be given to me, your lordship is taking up the second matter, because the rule part, your lordship will have to give a finding, because I had come on the first occasion, because I was downgraded, your lordship specified in the order that you need to grade instruction on the reasons why he was wrong, because that reason played its way to respondent number 8 taking over, because if it was, I was always on the top, that reason, if I get it, I'm satisfied that why I was downgraded. So while argument was being made, the government additional advocate general came up with a plea that since I will come up with the OM part, because basically they brought in the OM by bringing the catch-up principle, which they could not have done it. So what a learned advocate general, additional advocate general argued that we will consider his case dehors the OM. If it is dehors the OM of a submission made by an additional advocate general, the entire edifice of clause A of OM of 2018 goes, because it's an admission by the state government.
Mr. Das, that was, if I remember correctly,
Yes.
that was not his submission.
It was submitted, it was recorded.
That was not, Mr. Das. His submission was that dehors the OM,
Yes.
the petitioner will be considered. He is in the zone.
But dehors the OM, the petitioner will be considered, but the additional advocate general, after going through my petition, did not answer that by bringing me down. What were the reasons of I coming down? There has to be a reason, because my entire case was on that, because they could not have brought me down. And if a finding is there that they brought me down on these reasons, then I am satisfied. That is my case. And the minutes will specify.
Achha, in this writ petition,
Yes.
the notification dated 30th of January is under challenge.
Which one?
Mr. Das, have a look at this. Have you seen this or have you challenged this?
This I have already stated that as soon as I get a minutes,
Have a look at.
no, I cannot challenge it because this came out today. I got it.
That's right. So
Yes.
you are aggrieved by this. Are you?
I'm agree.
Are you? Challenge it by filing an
Yes,
additional.
I've already said that I'll challenge the minutes and this will be in part of the records your lordship will allow. I've made it.
All right. On the prayer of Mr. D.K. Das, learned counsel appearing for the petitioner. Leave is granted for filing an additional affidavit challenging the notification dated 31/2023, giving promotion to the respondent numbers 7 and 8 to the post of chief engineer in the water resources
I'll
department.
not press for 7. 7 is retired.
Okay.
8.
Challenging
He's
the
already
promotion given to the respondent number 8. That's also. How much time should we issue notice today?
Malad, only one prayer I want since I wanted early adjudication. Your lordship, I'll press for an early hearing. Because the reason is I need to know my position why I was downgraded. That could be the only.
So that they will have to file an affidavit.
Yes, so if your lordship specifies it, because the problem is that it has happened in the earlier occasion. I don't say anything about the private respondents. The government taking time for the simple reason he has 4 months to go. I need to know whether what will be.
Who has 4 months?
This, the respondent has 4 months to go.
And when is your client?
And I'm retiring in the month of December of this year. But if the adjudication is done, at least my case is built up only on one, then why I was brought down.
Right. So we'll issue notice at this.
Yes, yes. And your lordship will make the promotion provisional subject to the outcome. Because it's under judicial scrutiny.
Heard Mr. D.K. Das, learned counsel appearing for the petitioner. Peruse the amendments made in the writ petition. The petitioner hearing, who was a candidate in the zone of consideration for filling up the post of chief engineer, bracket quality control, bracket close, in the water resources department, has approached this court, primarily being aggrieved by the notification dated 31/2023,
Yes.
by means of which the respondent number 7 was promoted to the post of chief engineer, bracket QC, bracket close, and pursuant to his retirement
Respondent eight.
with effect from 31/3/2023, comma, the respondent number 8 was promoted to the said post, full stop. According to Mr. Das, had the petitioner's seniority not been downgraded, his client would have been selected as the chief engineer quality control, full stop. This said submission of petitioner's counsel has however been strongly refuted by Mr. D. Majumdar, learned additional AG Assam, as well as Mr. K.N. Chaudhary, learned senior counsel, appearing in this case on behalf of the respondent number 8, by contending that the petitioner was also, the writ petitioner was also considered along with the other 2 departmental candidates. And since the selection was purely on merit, unless the minutes of the selection committee is interfered by this court, the petitioner's case would have no legs to stand. First up, after hearing submissions of both the sides, this court is of the opinion that the controversy involved in this writ petition can be resolved only on the basis of pleadings brought on record by both the sides. Full stop. As such, issue notice of motion returnable on before Holi or after Holi?
It has to be before Holi. Because the question is simple. Malad, I wanted.
I should have asked before Bihu or after Bihu. Made a mistake.
Malad, I want.
They say aim at the tree and you land up in the, aim at the moon and you land up in the.
Now this power is with your lordship.
All right, all
I
right.
want an expeditious hearing, nothing more.
Okay, okay, you made your point.
Yes, sir.
Returnable on 9/3/2023. Since, who is appearing for whom? Since Mr. R.M. Das, learned SC, water resources. Achha, who is here for? Who is for 1 and 2? No, who is assisting you? Since Mr. Ardhar, learned counsel, the learned government advocate Assam, and SC, WPT and BC has appeared and accepted notice for respondent numbers 1 to 5, 1 to 6. Mr.
Goswami.
SK Goswami for respond number 8. 1 to 6 and 9. Yeah. For respond
Seven,
number,
I don't know. He is retired.
respond number 9. Service of notice is deemed to be complete on respond numbers 1 to 6, 8 and 9. Extra copies of the writ petition be furnished to the learned departmental council. Since the respond number 7 has already retired from service, his presence would not be necessary for a just decision of the contentious issues raised in this writ petition. Stop. Therefore, the name of the respond number 7 is hereby struck off from the array of parties registered to make necessary endorsement in the cause title. Full stop. The departmental council is directed to file affidavit bringing the minutes of the selection committee on the record of this case on or before 27/2/2023 by serving advance copy upon the petitioner's counsel. The writ petitioner may file rejoinder affidavit within a week thereafter. Full stop. This writ petition shall be taken up for further consideration on merit on 9/3/2023.
9, I will not, I won't be.
Then make it
14.
14.
I just,
14.
my lordship is given on 9th of March.
Yes, yes.
Let it be on 21st.
21st of March.
Yes. I won't be there. I'll be on leave.
All right.
Can it be before?
What will
that?
happen to your client in between?
Basically, my client.
He can take a gap, man.
Your clients will be out of water if you are on leave.
I won't be there on. Then your lordship may fix it on an earlier date. Can your lordship fix it on 2nd?
No.
Then that day, your lordship can fix it on 1st, 2nd, and 3rd. That will be better.
Actually, let it be second.
Second, that will be better.
By that Supreme Court matters will go on. That's why
Let
let it be 9th is okay, man.
9th I won't be there. Let it be on, if it is not, because some records will come at 2nd, lordship will keep it. We'll accommodate. That's not an issue.
Actually, let's see what happens on 2nd.
Yes.
If you have a prayer, notice is returnable on 2, 3. So let this matter be listed along with which are the other cases?
Item number 40, 41, WPC 405.
405 of 2023 and
No other, man. No other.
No other man. And it's provisional, subject to that.
the
And I may be
promotion
furnished a copy.
given to the respond number 8 shall be subject to further orders that may be passed in the writ petition.
Lordship, I will be given a copy of, at least today I am entitled to it. An open government concept.
Let
is
41 be called up.
there. Yes.
Actually, 5 and 6 are in this and rest are done.
My lord, the name of the council of WPT may be shown in the this.
This is the matter so and so by reflecting the name of learned council, departmental council in the Congress. Yes. Mr. Das, please wait. We will, when we take up that matter. Yes.
In this case, my lord, in spite of the direction of the Disciplinary Court, the SLC has rejected the case of the petition on the same ground by the impugned minus dated 16/8/2022. The direction of this honorable court was, my lord, on the 21/4/2022, page 52nd, my lord. On the same ground, they have, for the second time, they have rejected, my lord.
Agreed by rejection of his case for appointment on compassionate ground. The petitioner has approached this court for the second time by filing this writ petition, seeking a writ of mandamus. So I peruse the amendments made in the writ petition. Stop. Ms. A.K. Talukdar, learned. A. Talukdar or A.K.? A. Talukdar, learned government advocate Assam. Mr. R. Dhar, learned standing council.
1, 3 and 5, madam.
Standing council PWD and Ms. A. Talukdar, learned government advocate Assam have prayed for some time to obtain instruction of the matter. Prayer allowed. NOM 6 weeks since Mr. Dhar has appeared and accepted notice to respond numbers
1, 3 and 5, madam.
1, 3 and 5 and Ms. Talukdar for 2 and 4. Service of notice is deemed to be complete in this case. Extra copies of the writ petition will be furnished to the learned department council. within a week from today in order to enable them to obtain extension.
My lord, may I pray for pendency of this case shall not be barred for placing the case of the petitioner in the next SLC, my lord.
Now, how can they? They've already rejected. How can they do it?
Obliged lordship.
Time being matter, item 6.
I'm told money everybody has come.
Lordship, we have filed affidavit, Lordship, affidavit is on record, Lordship.
Yes.
Lordship, in the said affidavit, Lordship, paragraph,
Where is Mr. Mahanta?
he is on leg, Lordship.
So he is asking for an interim relief. We'll consider it now.
Lordship, he could not succeed, Lordship, in the screening test, Lordship. He fraudulently entered into the Lordship. What happened, Lordship? While he filling up the form, Lordship, he has an MTech degree. He stated it to be diploma engineer, Lordship. That's why he could chance to appear in the screening test. Otherwise, he would not have, Lordship.
When is the interview?
Lordship,
Today, tomorrow, and day after.
So he wants an order to provisionally allow him to participate in the interview.
Lordship, subject to your order, Lordship, my submission is that the candidate who could not succeed in the screening test is not entitled, Lordship.
Others also rejected, my lord.
Where is Mr. Mahanta? Can you? Yes.
In their system, my lord, there is no other degree. It is to be diploma. If you online application, below also can see diploma mechanical engineering 3 years. Then next year you also can come. Say 25. Energy engineering 5 years. What is the question of fraud or suppressing there? Next page, page 25.
What is the affidavit of the APS? Where is the affidavit?
Yes. Affidavit.
What is it stated in the affidavit?
The affidavit meant
Para?
page number 3, my lord, para 2.
Yes.
The screening test as per advertisement dated so and so held on even as the petitioner honorable commission decision that every application of shape post are allowed to appear in the scanning test provisionally without scrutiny of the uploaded document. The post of scanning test of the online application from the all prepared and candidate was screened, and on that it was discovered that Mr. Kaushik Saikya uploaded possess 5-year MTech degree in engineering, which is no means to comply with the equivalent education qualification. Hence, the name of the petitioner was regarding the rejection after the rejection letter. One also, my lord.
So petitioner is an MTech degree holder.
My lord.
He is not qualified to become a MVI.
As per advertisement, my lord, 3-year diploma is required, my lord. 3-year diploma is that. Even then, my lord, he actually as per the advertisement, those who are possessing 3-year diploma, my lord, their application should be accepted. Otherwise, not accepted, my lord. But here, my lord, what he has done, my lord, we are not, as soon as we are eligible candidate, all are eligible at the time of receiving the application, my lord, all are allowed to appear. But in the application, it is clearly mentioned that, my lord, your lordship kindly see, it is subject to, my lord.
Where is the advertisement? Page number?
Your lordship kindly see. Advertisement, my lord, at page, my lord, page 18 of the petition, my lord, please.
Yes, which is the clause about qualification?
Educational qualification. Clause 5. SSLC, SSLC with 3-year diploma in automobile or mechanical engineering from a recognized institution, Government of Assam, Government of India, and also duly recognized by the AICTE.
So petitioner is an MTech in which branch?
MTech in, my lord, energy engineering.
Huh?
Energy engineering. Well, even, my lord, what happened, my lord?
No, just a minute. MTech, is he an MTech in automobile or mechanical engineering?
No.
Mr. Sharma, is he an MTech?
Page 17. It is integrated course, my lord, page 17, lord. 5 years course, my lord. Electrical engineering, mechanical engineering, renewable energy specialization, energy engineering, the project. So mechanical engineering is also there. They are all 100 marks papers.
No, that will be difficult, Mr. Sharma. If the advertisement said a diploma in mechanical, and he turns out to be a person who is a BE in mechanical or MTech in mechanical, then we can understand. We can, as a court, we can straight away come to a conclusion that he has the requisite qualification, but more than what is required.
Yes.
But bifurcating degree, energy, and assessing which component of that matches with the educational qualification, that will be
But
difficult.
mechanical engineering is required, yeah. Mechanical automobile.
That will be difficult. It cannot be done by the court.
5 years course, my lord. These are the some stuff.
That's correct. Because you see, we will have to follow some principles.
But that is true.
That principle has to be something which is discernible, which is borne out on the face of the record. We can't become experts in energy engineering has various components. One paper could be of mechanical, but we cannot say that because it is mechanical, one paper is mechanical, so is a mechanical.
No,
That-
my lord, may I submit, my lord? Here, electrical engineer, mechanical engineer, they are relevant for the automobile engineering nowadays. Because now EVs are coming, electric vehicles are coming, there is, of course, now they are taking off, the diesel and petrol will go up.
Hmm.
So, my lord, these two subjects are not irrelevant in the present day, in the coming days.
Hmm.
So, my lord, here the mechanical engineering also subject. He is MBI, my lord. He is not even the DCO or high post. MBI, controlling the, my lord, vehicles. So, my lord, otherwise he should not be declared disqualified.
No, we are unable to agree with your argument. Because there are various courses, for example, some law courses
Yes,
where there is a paper in economics and political science.
yes.
Can it be said that a law graduate should be appointed as an economist? Can you claim that this is an equal qualification? But be that as it may, we are only concerned whether the authorities are arbitrarily or irrationally rejecting your candidature. That's the only concern. Court proceeding, we have to go into that only.
That is true, my lord.
Now, if they would have said that we want a diploma in mechanical, but he is a master in mechanical, so we will not take him. We can understand the irrationality. But what you are saying is he is a MTech in some other branch, which has some components of mechanical. That would be going into the finer aspects. Difficult. You conclude your argument.
Yes, my lord. All 5 years, my lord, they have to read these subjects. All 5 years they have to read these subjects. Because he passed out higher secondary, then 5 years course. He cannot, it is not 1 year mechanical, another year engineering, no. All 5 years they have to read these subjects only. And my lord, your lordship has even allowed in interim order, my lord, subject to outcome of the requisition for the engineering only. It is not mentioned whether civil or mechanical anything, engineering is over. That interim order I have given to your lordships.
Interim order was passed.
Yes.
That was passed that time.
Yes. Now in the
As the court has already indicated,
yes.
you show us what is the irrationality in their decision. We'll direct. We are not going to go into which subject course should contain which course and what is the content.
Irrationality as such is not there, madam. But one thing is there, they cannot say that I am not qualified to apply for
We
this.
don't know. We don't know. What you are saying is your submission.
Yes.
How can we say that? We don't have the qualification to say that. The court, the judges are not qualified to say that energy engineering is equivalent to mechanical. We can't say that.
No, I am not sticking on energy engineering, madam. I am sticking on mechanical engineer only.
Have you done your graduation in mechanical engineering? What was the discipline of your graduation?
There was some after higher secondary, I go to my 5 years syndicate post. And in that, these 5 subjects are to be studied all 5 years.
Very difficult.
Because mechanical engineers there, my lord, electrical engineers there.
No.
These are the relevant subjects for the.
This is not in the domain of the court. We cannot.
My lord, it will be academic exercise also, my lord. Then, my lord.
Why?
He is already failed. He is not in screening case. He is already disqualified. Even if your lordship allowed it, yes, it will be taken as a qualification. He is not qualified in the, my lord, in screening case, my lord. So I have given the mark, my lord. In affidavit, I have clearly mentioned, my lord.
That he has stated and you are not willing to file any rejoinder. How do you expect the court to pass an order? Your client is
No,
not only not qualified, but he has even failed.
If they reject me in the interview.
Sorry, we can't entertain these matters. These are all unnecessarily, it will be lying here. Heard Mr. R.P. Sharma, senior counsel, escaped by Mr. D. Dole, learned counsel for the writ petitioner. We also heard Mr. T.J. Mahanto, learned senior counsel, extended by Mr. P. Director, learned counsel appearing for the APSC. That is respond numbers.
1, 2, and 3 of this.
Respond numbers 1, 2, and 3. Full stop. Miss M.D. Bora, learned standing counsel, Transport Department, Assam, is present on behalf of the respond numbers 4 and 5. Full stop. The the Undersecretary to the APSC had earlier had on 25/5/2022 issued an advertisement for recruitment to the post of motor vehicle inspector. Full stop. Motor vehicle inspector in the pay scale of 22,000 to 97,000 plus grade pay of 9,400 in the pay band -3. Full stop. The educational qualification required for the post was HSLC/HSSLC with 3 years diploma, 3 bracket THRE, 3 years, you see in page 18, huh? 3 years diploma in automobile or mechanical engineering from a recognized institute of the government of Assam, government of India, and also duly recognized by AICTE. Full stop. The writ petitioner herein, who has done 5 years MTech course in energy engineering after his HSSLC, had also submitted his candidature. Full stop. According to the APSC, the petitioner does not meet the educational qualification as prescribed by the advertisement notice dated 25/5/2022. Yet he was provisionally allowed to participate in the screening test. Subsequently, it appears that the petitioner had failed to qualify in the screening test as well. Full stop. Contending that the petitioner neither has the requisite educational qualification nor has he cleared the screening test, the APSC has filed an affidavit contending that there is no scope for granting any relief to the petitioner. Full stop. Mr. Sharma, learned senior counsel for the petitioner, on the other hand, submits that the course of energy engineering, within course energy pursued by the petitioner, has a component of mechanical and electrical engineering, and therefore the petitioner should be treated to have the requisite qualification as per prescription in the advertisement notice. Full stop. Mr. Sharma further submits that his client be provisionally permitted to take part in the interview, which is scheduled to be held on today, tomorrow, and day after. Give the date. Full stop. Full stop. I have considered the submissions made by learned counsel for both the sides and have also gone through the materials available on record. Full stop. Insofar as the educational qualification of the petitioner is concerned, as noted above, the requirement is clearly prescribed by the advertisement notice, according to which a diploma in automobile or mechanical engineering is what is required. Full stop. It is the admitted position of fact that the petitioner does not possess a diploma either in automobile engineering or mechanical engineering. Full stop. Whether the course component of MTech in mechanical engineering includes mechanical subjects of mechanical and engineering to the extent indicated in the petition is correct or not, and if so, whether it can be treated as a substitute for a diploma in automobile and mechanical engineering are matters for the academic personnel to decide, and this court does not have the requisite expertise to go on the said aspect of the matter. Full stop. Suffice it to mention herein that by the own showing of the petitioner, he does not fulfill the educational criteria laid down in the advertisement notice dated 25/5/2022. This court is conscious of the fact that the petitioner has higher qualifications than what has been prescribed in the advertisement notice dated 25/5/2022, and he must also be looking for suitable employment so as to support himself. However, even if that is the case, the petitioner, even if that is the case, no mandamus can be directed, no mandamus can be issued by this court to accept the candidature of the petitioner if he does not fulfill the educational criteria. For such a direction would not only be contrary to the scheme of the advertisement, but would also tend to prejudice other similarly situated candidates who did not apply because of non-fulfillment of educational qualification. First of all, over and above the aforesaid position, it is also clear from the materials on record that the petitioner did not qualify in the screening test. Full stop. This said assertion of the APSC has not been rebutted by the petitioner by filing a rejoinder. Full stop. If that be so, viewed from that angle also, no writ of mandamus can be issued in this case, directing the respondents to permit the petitioner to take part in the interview. For such a recourse would lead to an entirely futile exercise. Full stop. For the reasons stated herein above, this writ petition is held to be devoid of any merit and is accordingly closed. Yes.
Order stayed again in license 23.
Lordship, we have filed a vacating petition, but if Lordship hears the vacating petition, it will be amounting to final hearing actually. So if the other side is going to file any further reply or something like that, then the matter cannot be taken up today. Otherwise, Lordship, the main hearing can be started from today itself.
Will it be inconvenient on Friday?
We have filed also affidavit as well as vacating
My
petition.
understanding is correct, my lord. Same exercise will be required whether to vacate the order.
What is the matter? Which department?
Veterinary department, animal husbandry and veterinary, and we are shortage of huge number of officers, Lordship.
What
There
is
a
the
stay
stay order? Can we just see this?
Yes, the order is page 49 of the affidavit in opposition in the IA number 3827. The interim order is of 29th November 2022. We are restrained from appointing.
1 minute. IA number?
28.
What is IA number 3?
3827. In WPC 7675.
1 minute. 1 minute. Yes. What is the page number, please, Mr.
Page
Secretary?
49.
It starts at my lord.
The operative part is at page 52, the middle paragraph. This court, after hearing the parties and on perusal of the procedures laid down under the APSC rules 2019, is of considered opinion at this stage that an interim order is called for. Accordingly, the state respondents are directed not to act on the results published by APSC on 23rd November, consequent to the advertisement of 22nd July 2020 till the next recruitment. It should be returnable date. The
So
issue
this is recruitment to which post?
Post of veterinary officers and block veterinary officers, AVO and VO.
So who are the writ petitioners?
Those who are not selected. And
What
they
is
are
the ground of challenge?
only one thing, that the rule has been violated according to them. There should have been a written test, but we have conducted only the viva interview. So that is the bone of.
They also took part in the interview.
Exactly, and they failed.
Your clients took part in the interview.
Yes. But my lord, we relied upon the Supreme Court judgment that Raj Shakti's case, my lord. If there is a violation of rule, then my lord, participation will not, have any effect. Here in the simple case, my lord, where the examination should have two components, written test and interview. Instead, only interview, based on interview, the selections were made.
All right. You are also appearing, Mr. Gujari.
I am appearing for a private respondent.
The selected candidates.
Acha, you see, final hearing as substitute of
Vacating.
vacating is a difficult proposition for the court, because if we go on doing it, we'll be mounting our. So I am ready to hear this matter whenever you want to argue. You want to argue today, I'll hear it. You want to argue tomorrow, I'll hear it. Let us see what is, stay vacating, either we vacate it or we maintain.
Day after tomorrow on Friday, Lordship.
First stay vacated.
Stay
For,
vacated.
but because Lordship said that it will be difficult to go for final.
No, because final hearing, we have to write out our judgments.
Yes.
And that will be a time-taking process. So if you
Right.
want that, then we'll put the matter.
Lordship will have it on Friday.
On Friday.
Okay, it'll be on Friday, but it'll go to some other court. This court is not sitting on Friday. So I'm making it clear.
Could it be on tomorrow then, Lordship? Or let us start today, Lordship.
Do it on Tuesday then.
Tuesday.
Let it be tomorrow. Tuesday, I've got all fixed matters. I
Tomorrow.
don't mind tomorrow.
On the request of learned counsel for both the side, let this matter.
Only thing is, my lord, also will have it in the second. Tomorrow. Yes.
Tomorrow.
Highly obliged, Lordship. May please, Your Lordship. Matter relates to compassionate appointment. Pursuant to last order, that is on 02/01/2023, direction was given to the petitioner to file an additional affidavit indicating the economical status of the petitioner. Complying with the state order, we have already filed our additional affidavit. That is also
Compassionate appointment, who has died?
the father of the petitioner.
When?
30/07/2007. Subsequently, we made an application on 08/10/2007 before the office of the Deputy Commissioner Sunit Peshpur, praying for appointment of the appointment on compassionate ground.
Yes.
But there was no response to that.
Hmm.
Then thereafter we filed in RTI.
Hmm.
Yes, 22/12/2014. The petitioner made an application regarding the status of his application.
Hmm. What do they say in the affidavit?
Your Lordship, he is an educated unemployed youth. He has no income of his own. So, and actually,
No, what is the stand of the department in the affidavit? They have
Yes.
filed affidavit.
yes,
What is their stand?
they have not replied yet.
Huh?
They have not replied yet.
They have not replied.
No, they haven't replied.
Are you sure?
Yes, because if they have replied, we would have got the service as well.
You must know your case. The respondent number 6 has filed affidavit in opposition. Why are you saying they have not replied?
We have not received any copy of that.
Now, that's what I'm asking.
We have filed it long time back. We have filed it on 3/5/2016. actually.
No, to this,
No, we joined the application.
that's a region. My apologies.
Hmm. So you don't know that respondent number 6 has filed affidavit.
Earlier, this matter was taken care of with some other.
All right, but are you aware what is there in the affidavit? What will you argue then if you are not aware what is the respondent's stand?
We don't have that.
Huh?
We don't have it.
You don't have it. You are ready to argue today.
Grant me some time.
All right. Your name, please?
AVC.
Huh?
AVC.
On the request of Mr. A.V. Singh, learned counsel for the petitioner, this matter stands adjourned for 3 weeks so as to enable him to examine the amendments made in the counter affidavit filed by the respondent number 6. Mr. D. Bora, learned government advocate Assam, to furnish a copy of the affidavit filed on behalf of respondent number 6 on 3/5/2016 to the learned counsel for the petitioner. This the matter accordingly.
I'll leave it.
Item 25.
One of these petitioners, numbering 12, they were appointed in 2016 in the Social Welfare Department, but they were not paid their salaries. And in spite of repeated directions, neither instruction nor affidavit.
Lordship, our instruction is that they have already paid, Lordship, but affidavit we could not file, Lordship. Give us some time.
They have been paid this.
Yes, in 2018 itself, Lordship.
No, current or earlier.
All that.
And since then, the salary is being paid regularly.
My instruction says.
If that is recorded, then I get my relief. Because I also, after 21, for a long time, I don't have any contact with the client.
It must be correct. Otherwise,
Yeah, otherwise they would have.
are your clients making your life hell? No, your
Yes,
junior, no.
that's
That means that is correct. They would not see it
So
quite.
if it is a written instruction, let it be placed on record and your lordship will record and dispose of the matter.
This is to the treasury officer. All petitioners are in number. Look,
Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. A. Burkotagi, Learned Counsel appearing for the writ petitioners. The petitioners herein were all appointed on regular basis as instructors, bracket WC, bracket close, comma, instructress, bracket KNE, bracket close, comma, junior assistant and supervisor, bracket regular, bracket close, which are all grade 3 posts under the respondent authorities. Full stop. Their selections were made pursuant to the advertisement notice dated 24/2/2014. And the petitioners had joined service in the year
2016,
16. Full stop. The grievance of the petitioners is to the effect that although they have been regularly appointed against vacant posts under the Department of Social Welfare, their salary and allowances had not been paid till the time of filing of the writ petition. Full stop. Today, when the matter is called up, Mr. S.S. Roy, Learned Government Advocate Assam, has produced a copy of the notification dated 5/1/2018, issued by the
last page was not there, Lordship. I'm just giving Lordship.
issued by the Under Secretary to the Government of Assam,
Lordship,
Finance,
SU
bracket, SIU, bracket close department, comma, a perusal of which goes to show that the area salary of the petitioners had been cleared way back in the year 2018. First of Mr. Roy submits that all the petitioners are receiving regular salaries since then, and therefore nothing survives for adjudication in this writ petition. Responding to the above, Mr. Chaudhary, Learned Senior Counsel for the writ petitioner, submits that if that be the case, then the writ petition be closed by retaining a copy of the notification dated 5/1/2018 with the record of this case. First up, the Learned Government Advocate Assam and Mr. P. Nayak, Learned Government Advocate Assam, Mr. S.S. Roy, comma, Mr. P. Nayak, Learned SC Finance Department Assam, and Mr. A. Hassan, Learned Standing Counsel for the Accountant General, Office of Accountant General, are present and do not have any objection if such an order is passed. In view of the above, this writ petition stands disposed of in the light of the observations made herein above. A copy of the notification dated 5/1/2018 be retained in the record.
Right.
Item 26.
May please, your lordship.
Yes.
My lord, here in this case, my lord, the petitioner challenged the input communication and except 13, whereby the private respondent has been granted approval for upgradation in the post of he is holding initially in the post of Anganwadi worker
helper now proposed for upgradation as an.
What is this upgradation business? How can you upgrade someone? Is it a ticket upgrading from economy class to business class? What is the meaning of upgradation in service jurisprudence?
Lordship, upgradation for there after when they are served for some particular amount of time, Lordship, there were some vacancy arises, Lordship.
So you upgrade and then suddenly downgrade, and these are all what is going on. Because of all these irrationalities, people are coming to court, filing writ petitions.
Lordship, in this case, Lordship, I have just received the records, Lordship. I have to go through them.
Well, there is an interim order here.
My lord,
Heard Mr. Yar Sigdal and counsel appearing with the petitioner, also heard Mr. S.S. Roy, learned government advocate Assam, who submit the records and therefore be granted 2 weeks time to examine the same and make submissions before the court. You are for?
Respondent number 6.
Mr. I. Ahmed, the learned counsel is present on behalf of respondent number 6, and Mr. T.K. Roy for?
Respondent number 7.
Respondent number 7. In view of the request made by the learned government advocate, this matter be listed again after 3 weeks. Interim order passed earlier to.
No, please, Your Lordship. In this case, we have challenged the award passed by the Learned Labor Court, reinstating the respondent one with full reacquisition. Also, a record of LCR also come for it. Fortunately, is the matter for hearing any other day.
My lord,
There is the interim order and they are getting the last door and notices, Lordship.
my lord, what I'd like to submit, my lord, the record is only a very short question. The ground on which they have challenged the award, the pleadings were not there. The basic ground for challenging this award is that they were not given the opportunity to adduce evidence after the inquiry was held to be that. My lord, that is settled now, that to raise this, they have to make it in the pleading that they would like to examine the fairness at the first instance, and then if the fairness is against the decided against the management, then they will be allowed to give evidence on merit. And Lordship may have a look at the charge, my lord.
What do you want today? What are you asking?
I pray for an early disposal because this lady is suffering absolutely for their illegal and arbitrary action.
But she is getting last door and wages.
Last on wages, my lord, she was dismissed in 2018. My lord, and
She was serving as what?
junior assistant, not nurse, junior assistant in Apollo Hospital. Lordship may for the moment look at the charge.
So agree on a date, we'll fix it.
My lord.
When?
After 2 weeks.
Agree on a date.
My lord, 16th of February, my lord. Or 14th. It is a Tuesday.
Mr. K. Kalita, learned counsel for the petitioner, and Mr. S. Chakravarti, learned counsel appearing for the respondent, have both submitted that the records have been received and therefore, and the matter calls for early disposal. As such, this writ petition be fixed for admission hearing on final disposal, fixed for final disposal at the stage of admission hearing on
16th February.
On 16/2/2023. First up, in view of the prayer made by counsel for both the sides, registered to wish this matter for admission as a fixed item on 16/2/2023. Along with the LCR, interim order passed earlier to continue till then.
Item 28.
Yes.
May kindly pass over and bring from short problem.
The arguing counsel for the petitioner is unwell and therefore not in a position to argue this case today. As such, on his request, his matter stands adjourned for 2 weeks. Mr. C.S. Hatharika, learned government advocate Assam. Who else is there?
I appear for respondent number 12.
Appearing for C.S. Hatharika, respond numbers?
Lordship, 1, 2, 3, 4, 5, 6.
1, 2, 3, 4, 5, 6. Mr. R. Dubey for respond number, learned counsel for respond number 2, and Mr.
12.
12, and Mr. S. Biswas
For number 7.
for respondent number 7 are present and do not have any objection to the prayer. List accordingly. Yes.
Item 29.
Yes. The case for the condemnation of break service of the petitioner, my lord. The petitioner, the break is come to a break is from, my lord, 25/1/2007 to 23/7/2014, my lord. This period, my lord. Actually, petitioner, he was initially appointed on contractual basis in the Social Welfare Department in 1995 at a contractual payment of rupees 900. And thereafter, department had held interview, and in interview he was selected, my lord, and selected and was appointed as LD assistant in the establishment of a project of the ICDS in the Mazuri, my lord. The annexure the poll in the appointment letter subject to satisfactory police verifications and the report and medical fitness certificate from competent authority, and as per approval of the district selection board, they constituted by the constituency Sajid Ansari, so and is hereby appointed as the typist. As the typist in the.
Where is the order dated 14/11/2013?
My lord.
Where is the order dated 14/11/2013?
Order 14/11 order. It is 2001, my lord. He was transferred to Majuli, my lord, and thereafter.
Sorry, I can't hear this matter. You are not giving me the answer. Where is the order of the court to reinstate you? Where is that order?
The registration order is here, my lord. Annexure 9 page 52, my lord. Judgment. Judgment of. Actually, dispute was when she was 2006, he was appointed transferred to Boroboro, Dibrugarh district, my lord, in the same capacity. But in the interview, one normal secretary, his position was second, and petitioner position was the 6th, my lord. So the normal secretary was not appointed. That is why he filed his petition, my lord. When the petitioner filed, the petitioner was removed from the service, and she was appointed. The normal secretary was appointed, giving reference of the Honorable High Court order, but High Court order has not stated that the Sajid Ansari should be removed and Normal Ansari should be appointed.
You filed your affidavit?
Lordship, may I please, Lordship? Affidavit of opposition of Lordship 1, 2, and 3, 1, 2, 3, and 4, Lordship, and actual 1, Lordship. Lordship, kindly produce the page number. And actual 1, Lordship. The appointment of the petitioner was cancelled, Lordship. Lordship, the last portion of the paragraph, Lordship. The matter was reported to the government of Assam for necessary advice. The government of Assam in the social welfare department filed letter to the so-and-so advised the undersigned to appoint Srimati Narmada Chetri in place of Mohammed Sajid Ansari, petitioner, Lordship, who is at present working as LDA typist at ICDS project, Dibrugarh. Hence, the appointment of Mohammed Ansari, LDA typist, hereby is cancelled, Lordship. His appointment was cancelled. And Lordship.
So you want continuity of service during
Yes,
that time. That cannot be done because of Dias non-principle. We have the judgments.
The removal was illegal, my lord.
Yes.
The annexure 7.
No, the learned single judge did not say that it will be continuous. No,
No, that is right, my lord. But the removal is, my lord, giving reference of the case filed by the Narmada Secretary, WPC number, my lord, 869/2000. They giving, but in that order, Honorable High Court has not stated that the Sajid in place of Sajid Ansari, the Narmada Secretary should be appointed. He was removed illegally, my lord. That is why he was compelled to file a petition, and his petition was allowed, and he was ordered to be appointed. And accordingly, he was 2014, he was appointed. On that period, when he was illegally removed from the service, giving the false defense of the judgment of the Honorable High Court,
So he's
No,
entitled
no,
to-
the learned single judge in that case, see, his appointment is pursuant to that order.
Yes.
In that order, whatever the order was given, was given.
Yeah.
The learned court only said, give him, reinstate him back. But you are at liberty to appoint the private respondent in another position.
post.
That's all.
Yes.
The learned judge did not say that give him back wages, continuity of service.
But
So
why?
this
why-
cannot be done in a subsequent proceeding.
Why?
And that is because of the principle of dias non. Are you aware of it? If you are not aware, you will say something, I will write something.
My grievance is why I am illegally removed.
That is
by-
maybe a grievance,
Your-
but that is not permitted under the law.
Your lordship has not stated that I should be removed and in my place Navada secretary should be appointed. There is no reference of the case filed by the Navada.
All right, on the
secretary.
request of Mr. K. Sharma, learned counsel for the petitioner, hearing of hearing of these matters hence adjourned for 4 days. You try it somewhere else because I am clear of the law. I cannot accept your argument.
After how many-
Mr. A. Talukdar, learned
After-
government advocate Assam is present on behalf of the state after 4 weeks. You do not have a case, Mr. Sharma. You do not have a case. Because in that order, if the court had mentioned that he should be given a benefit of.
That case I have not conducted. I
No,
was-
you have not conducted me. We are not telling you personally. This is to the petitioner. This is not of any consequence to us. Who has conducted?
I am coming only on that point that I was removed giving reference to the case filed by the.
You are right. I have understood it. But in that proceeding, in the order of reinstatement, it was not mentioned that his service will be treated to be
If
continuous.
it is mentioned, then there is no problem.
That-
But not
that's the
mentioned,
problem.
That is a way to file this petition again.
Now it cannot be done because it will now come under the principles of dias non.
No, because otherwise my pensioner is.
Do you know what is dias non?
Pensioner.
Have you heard about this? All right, next matter, please. Please.
Item 31.
Yes.
There is some particular difficulties, one time will be required,
Mandate.
Huh?
A date may be fixed, my lord, because already pleading already complete. Date may be fixed, my lord.
Mr.
Hassan.
F.A. Hassan, learned counsel submits that due to some personal difficulty on behalf of the arguing counsel, this matter be taken up for admission hearing on some other date. Full stop. Mr. A.K. Datta, learned CGC, on the other hand, submits that the records have been received and there is some urgency in the matter. Stop. As such, a firm date may be fixed in this case. On the request of learned counsel for both the sides, let this matter be listed again on 21/2/2023 as the fixed item.
Item 33.
Matter relates regarding to the admission into the lordship, recorders courts like and Lat Mondol, etc. Lordship. Petitioners are selected for training, but respondent authority not send the petitioners lordship. Their stand is there.
His submission is not correct. He was not selected.
Selected lordship, there is a list lordship.
Where is the list?
List lordship, kindly see in the lordship annexure 46. Annexure 46 successful and unsuccessful candidate lordship. Out of more than 100 applicants lordship, they have selected 39 candidates.
What is the name of the petitioner?
Dipankar Nath lordship. He is
How-
unsuccessful. Unsuccessful means lordship, they have not sending in the training. Yes, lordship, they have originally 39 candidates selected lordship. 39 candidates selected out of the total applicants lordship. Petitioners appeared in the written exhibit.
So according to you, unsuccessful means successful.
Not lordship.
Then
This list is only for sending to the training lordship. Out
Yeah.
of these selected candidates, total 39 was originally selected. Within the 39 candidate lordship, they have prepared another list, successful and unsuccessful. This is two lists lordship. So what happened lordship in the
where is the list to show that your client was selected?
yes, lordship.
Where is it?
Kindly see Lordship. In the Korimganj district, page 39 Lordship. Page 39 Korimganj district.
Yes.
KJ 271 Lordship.
Huh?
KJ 271 petitioner number 1 Lordship. KJ 271 in column 2 Lordship is there Lordship. Page 39 against Korimganj district Lordship serial number in.
That is for to appear in the vivacy interview.
Yes, Lordship.
That's all.
Yes,
What
Lordship.
happened in the vivacy? After the vivacy?
After the vivacy Lordship, what happened? They have only 20 candidates sent to the.
Where is your name in the select list? I'm going to dismiss it with cost of 50,000.
No.
Mr.
What happened?
Don't waste the court's time. Where is the list where your client has been
Then
selected?
Lordship, pick any other day, I will prepare.
I'm dismissing with 50,000
No,
rupees.
no, there is the order, Lordship.
Sorry. But
Can you the order
Mr.
dated
Was you selected?
47 Lordship.
Show it, otherwise there
I
will
will
be cost.
produce, I will produce Lordship.
47 Lordship. Kindly see.
You will produce what? All right.
Any other day.
In
Lordship,
this
I will
writ petition, a prayer, the basic grievance of the petitioners is that although they were both selected as for appointment as Lot Mandal,
Not appointment.
Then-
For my lord,
Not appointment,
RCC training Lordship.
Pending
for undergoing
training.
training in the post of
My lord, that recorders course, class course certificate.
This is a
Recorders-
course, Lordship, not appointment.
course certificate. Yet the petitioners were not ultimately sent for the training,
Yes,
whereas 39 other similarly situated selected candidates
yes, please.
were sent for training.
Only 20
Uh,
candidates sent for training. Out of
Mr.
30.
Only,
20.
whereas 20 other candidates who were similarly situated and were selected and were shortlisted
Yes, please.
by the authorities have been sent for training. Mr. Responding to the above, Mr. J. Henrik, learned Standing Council Revenue and Disaster Management Department, Assam, submits that the petitioners were never shortlisted, and therefore the question of sending them for training did not arise in this case. Full stop. Mr. ABT Hawk, learned counsel for the petitioner, submits that his clients were shortlisted, but the learned counsel has failed to point out any document to substantiate his argument. If that be so, this case appears to be nothing but an abuse of process of the law, whereby important judicial time of this court has been wasted. Be that as it may, on the request of Mr. Hawk, this matter is directed to be listed again on 9/2/2023 as a fixed part-heard matter, so as to enable the petitioner's counsel to substantiate his argument. If you cannot substantiate your argument, 50,000 rupees will be imposed.
If there is an order also of this honorable court in.
You have to show me where your clients were shortlisted. You show me, you get the relief. You don't show me 50,000. We'll ask the SP to recover the amount. Yes.
All right.
Item 34.
Matter, the affidavit of the respondent number 3, the finance department is awaiting. On the last occasion, they sought.
Heard Ms. D. Bordwine and counsel for the petitioner also heard Mr. P.
Yes,
Nayak.
but
Where is that?
I received on 13th of this month also.
Mr. P. Nayak, learned Standing Council Finance Department, Assam said to submit that he has received instructions and therefore you have to file affidavit.
Yes, Lord.
And therefore be granted 3 weeks further time to file affidavit. Para allowed as a last chance. Mr. J. Henrik, learned Standing Council, Revenue and Disaster Management. You are appearing to Revenue and
Lord.
Disaster Management, Assam is present on behalf of the official respondents. List the matter again after 3 weeks.
Item 35.
May please, your lordship.
Yes.
Actually, the petitioner is the settlement and not declared the result of the model on 7/2/2021. Till date, result are not declared, my lord. And already responding of court has filed their affidavit, and there is no anomalies in this clearly stated matter.
There is no anomaly.
Yes, my lord, just clearly stated in page number 23 in affidavit in opposition, filed by the respondent number 4, my lord.
So if there is no anomaly, then we'll close it.
Yes, my lord, but as per the order of the 9/12/2022, Honorable Court has passed an order, my lord, this tendency of the instant repetition shall not be barred upon the declare the result, but till that result is not declared, my lord.
The select list was, the process was extended till 31st March 23. Maybe the results will be declared prior to that, but I have no instruction as to when the results will be declared, Your Lordship. But yes, the process has been extended till 31st March.
So result will be declared. What is the problem?
Problem is, my lord, this because this age is going on and my lord.
No, age is going on. What are their conditions will be considered on the date of application. That's not a violation of fundamental right.
Yes, my lord.
Then heard Miss
B. Devi, my
B.
lord.
Devi learned counsel for the petitioner. The petitioners are aggrieved by failure on the part of the respondents to declare the results of the interview and written test held for selection of Lot Mondal. Lot Mondal,
Yes,
is
my
it?
lord, Lord, my lord.
Mr. C.S. Hagarika, learned government advocate Assam, and Mr. J. Hendik, learned standing counsel, Revenue and Disaster Management Department Assam, submits that the selection process is determines that the matter is still under process, and there is a strong likelihood that within next few weeks the results will be declared. First of all, since the only grievance of the petitioners is on account of the fact that the results of the selection process have not yet been declared, this court is of the opinion that this on the request of the learned department counsel, these matters should be listed again after 6 weeks. In the meantime, necessary instructions be obtained by the learned standing counsel, Revenue Department Assam.
Instruction waited, my lord.
They took time for filing affidavit.
Instruction waited for how long? Heard Mr. P.K. Das, learned counsel for the petitioner, also heard Ms. D.S. Neog, learned standing counsel, Irrigation Department, Assam, who prays for and is granted further 4 weeks time to obtain instruction in the matter. List the case accordingly.
Obligement.
Item 38.
May I please, Your Lordship? Lordship, yesterday the respondent counsel filed a reply. The action was there to file a reply early so that I could file the reply. Matter pertains to removal of service arbitrarily from the Reinstatement, post of Reinstatement. I may be given a week's time to file my counter.
Mr. K. Mahanta, learned counsel for the petitioner, submits that in terms of the order of this court, the respondents have filed their counter affidavit only yesterday. And therefore, he will be granted 2 weeks time. You take 2 weeks time to examine the same and file rejoinder if so required. Full stop. Mr. P.S. Lahakar, learned CGC, is present on behalf of the official respondent. On the request of Mr. Mahanta, this matter will be listed again after 2 weeks on a fixed date, on a date to be fixed by the registry.
Matter will be this affidavit is not on record, so kindly document.
In the meantime, counter affidavit filed by the respondents be brought on record.
Obligation.
Item 39.
May I please, Your Lordship, this matter already pertains to the writ petition that is filed by the petitioner, challenging the order dated 23/11/2022 and 12/12/2022, wherein the Honorable Court has already heard this matter on last occasion and has actually asked the respondent authorities to get an instruction from the department. Since the petitioner is willing to take an undertaking regarding that, he will be transferring to the post he has been transferred to after April 31st of March. He is going to undertake that particular.
During pendency of the case, yesterday evening, he has filed an undertaking before the authority, before the CPMG, stating that since 1/4/2023 or either 36/23. Regarding his some illness is going on, treatment is going on, that is if considered by the authority. How the matter is pending before this one, how the authority again consider?
So give him time till 1st April.
One instruction or instruction from the department is that in each and every school, my lord. Yes, next session will be from 1st of April, my lord. But almost during first week of March, my lord, it will be over, my lord. All exam over. Therefore, thereafter re-examination, and the next session will be start from the 1st of April, and all the CBSE schools, my lord. So, my lord, from a department, my instruction is that my prayer under instruction that till my lord, the 1st of March, my lord. My prayer that
This is bargaining.
no,
Bargaining you can't,
no, my lord,
not in this court.
the fact is that my lord, because my lord, first that next session will be start from 1st of April in CBSE schools, and here only that
31st of March, provided he gives an undertaking that under any circumstances, he will not continue or he will not seek extension of this order.
that any is not given. He is
No, if he gives that within 7 days, otherwise the department will be at liberty to
my
take
lord,
appropriate action against
that may
it.
be clarified.
Yes.
My lord, I have a copy of him, which has been unofficial, since he has already given it to the department, but since he independence of the case, this might not be considered. But I have a copy where he has already undertaken, where he has actually stated that if it is 1/4/2023 or 36/2023.
No, not 36.
That is fine. There are two options. So basically, he's opting for 1/4/2023 or 36.
31st of March 2023, he has to join.
My lord.
If he doesn't join, otherwise you tell us, we'll pass an order on merit.
My
You
lord,
know
on
what it means.
1st of April.
All right,
Oh,
1st of
oh,
April,
my-
yes. Take down.
But-
Hard,
but-
Mr. Huh?
My lord, my that submission may be, my lord, for the sake of the department, my lord.
Which submission?
That for the department, my lord, up to my lord, last of
first of
February, first week of March, my lord.
All right. Take down. Hard, Mr.
WR Medi.
W.R. Medi, learned counsel appearing for the writ petitioner. Also heard Mr. K.K. Poraswamy, learned CGC appearing for the respondents. Full stop. The basic challenge in this writ petition is pertaining to the transfer order dated. What is the transfer order?
23rd, 11th, 22, my lord.
That's Annexure A. Page number 20.
23/11/2022 bracket annexure A issued by the authorities transferring the petitioner from Tejpur and posting him as senior superintendent of post office, Kachar division, Silchar. Full stop. According to the petitioner, the transfer order is in clear violation of the policy guidelines in as much as he is being sought to be transferred before completion of the entire tenure. Full stop. The learned departmental counsel, on the other hand, submits that the order of transfer has been issued in exigencies of public service, and the law is well settled that a departmental candidate can be transferred even on one day, even within a day, if the exigencies of public service so demands.
And
You don't want to say this?
That is also, and already, my lord, 3 years of tenure already covered. He's saying the 4 years, 3 years.
It is
already
also the
covered.
submission of Mr. Parasar that the petitioner has already completed 3 years in his present place of posting, and therefore there is no ground for this court to interfere with the transfer order.
My lord.
Full stop. While appreciating the arguments advanced by learned counsel for both the sides, this court has also taken note of the fact that the petitioner has a
As a 9-year-old daughter.
9-year-old daughter who is in
In
need of
standard 6, is studying in standard 6.
studying in class 6
Class 6.
in a school
Oh,
at
Saint Joseph.
Tejpur, in the St. Joseph School. If you are not correct, you have to come again. Yes.
My lord, yes.
9-year-old daughter
9 years,
who is
3 years.
in a mid-academic session.
Class 4, 9 years old.
In a mid-academic session, and therefore, if the petitioner is compelled to shift from Tejpur to Kachar, Sonitpur to Kachar at this stage, then the academic career of his child will suffer. Full stop. Taking note of such circumstance, this court had passed order dated What is the, where is the order? of this court?
28/12/2022. Interim has been.
No, this matter was posted for taking,
My lord, yes, on 27.
Interim
the 27 order is not even there. Where is this? There are two writ petitions.
No, one is IA, my lord.
There is an IA.
IA filed by us.
Yeah, they passed an order dated 27/1/2023 in the stay vacating application filed. Now, by virtue of an interim order dated 28/12/2022, the petitioner is continuing in his present place of posting at Tejpur. Full stop. By the order dated 27/1/2023, on the stay vacating application filed by the department registered as IA (C) 207/2023, arising out of WPC number 8455/2022. The court had requested learned counsel for both the sides to seek specific instruction as to whether the petitioner can be permitted to remain in his present post till 31/3/2023, and if so granted, will the petitioner be willing to execute an unconditional apology? Full stop. Today, unconditional undertaking to that effect. Today, when the matter is called up, Mr. Parasar submits on instruction obtained from the departmental authorities that they are willing to allow the petitioner to continue in the present place till
28th of February. my lord.
till 28th of February 2023. Mr. Mehdi, on the other hand, submits that his client is seeking time till 1/4/2023 to join in the new place of posting, and to that extent, he is willing to give an undertaking. Full stop. The fact of the matter is that on 28th of February 2023, the petitioner's daughter's academic session will not be over. Full stop. If that be so, no practical purpose will be served by directing him to join in the new place of posting on 28/2/2023. Full stop. Therefore, taking note of the overall facts and circumstances of the case, as well as the stand taken by learned counsel for both these sides, this writ petition and the IA is being disposed of by providing that if within 7 days from today, the petitioner submits an unconditional undertaking before the respondent number,
My lord,
undertaking in writing before the respondent number,
my lord, PMG, my lord.
so and so, stating that he would join in his new place of
Two, my
posting,
lord.
respondent number 2, join in his new place of posting as per the transfer order dated 23/11/2022 on or before 31/3/2023, then in that event, the petitioner shall be permitted to continue in his present place of posting till 31/3/2023. Full stop. It is, however, made clear that if for any reason whatsoever, the petitioner fails to give such written undertaking, unconditional written undertaking, and or fails to comply with the undertaking given by him, then in that event, it would be open for the authorities to take further action against the petitioner in accordance with law without serving any further notice upon him. So with the above observation, the writ petition and the IA stands disposed of. Yes. All right.
All right.
No, item number 40 is connected with, today instruction was sought for.
Yes.
For the chief engineers. Connected with item number 21.
Acha, you give me the writ petition, please. The writ petition. Yes. So, Mr. Das, you
Yes.
want to know what has happened
Yes,
in the.
I want to.
So he is entitled to know. You have to give him that.
My lord, yes, they're supplying on.
On the category. Well, they say that they have one copy.
No, the seal copy, seal cover, yes, my lord.
What is still about it? Promotions have been given, let him
Yes, my lord.
take it. You take it and
Yes.
in the meantime, they'll file their
Yes.
affidavits.
My lord.
Yes.
Well, it will be fixed on the date which your lordship had given in the.
What is the date fixed?
It is 2nd of March, the lordship has fixed it. On 27, they have to give their affidavit. 1 week thereafter, I give my reply and the matter is laid.
But in the writ petition that he has moved in the morning, he has made a specific mention that this petition has become infructuous. He himself has said. It is a pleading manner.
He didn't mean it.
Yeah, normally he does that, my lord. He says something but pleads something else.
Not at all.
As
my
your
lord.
lordship has pointed out this morning.
No, my lord.
No, it's not at all. Mr. Das is trying hard to get some relief to his client.
Absolutely. He's entitled.
You all are blocking it again and again.
Yes, well, through an OM.
Yes.
And OM has overridden my judgment, which has
What
gone.
to do?
Well, I have not got the fruits of a judgment. Well, nowhere in this country, fruits has not been. I am entitled to it because in the appeal also, it was not admitted by the Honorable Chief Justice.
Anyway, for now, we'll fix this matter on 2, 3.
Yes.
You're right. I had Mr. B. Das,
I want an expeditious hearing. I need to know the adjudication.
Counsel for the writ petitioner. I also heard Mr. D. Majumdar, learned additional ID Assam appearing for, assisted by Mr. R.M. Das, learned standing counsel, Water Resources Department appearing for the respondent numbers. Yeah, respondent numbers.
One, two, three, four, I'll represent my lord along with Mr. Dhar.
Who is Water Resources?
He is for water. 5 and 6 he will represent.
Mr. So-and-so assisted by Mr. R. Dhar.
1 to
Learned
4.
counsel appearing for the respondent numbers 1 to 4. Mr. R.M. Das, learned SC Water Resources Department for respondent numbers 5 and 6. And Mr. S.K. Goswami, learned counsel appearing for the respondent number 8. Mr. Das submits that the pursuant to a selection process, the respondent numbers 7 and 8 have already been promoted. But no copy of the proceedings of the selection committee has been furnished to him. First up, in this matter, the records were called for, and Mr. Majumdar submits that copies of the proceedings of the DPC will be furnished to Mr. Das during the course of the day. And the authorities would also file an affidavit bringing the facts on record. In view of the above, let this matter be listed again on 2/3/2023 along with WPC number 499 of 2023. Parties to exchange pleadings in the meantime. All right. We exchange with
In fact, a date has been given within 27th of this.
Yes, that will be followed.
Because
Lordship may kindly observe that the proceedings of the DPC have been already produced before the court panel.
I add one line. The proceedings of the DPC have been produced today. Full stop. I have perused the same. The records be again produced on the next date fixed.
obliged. 7 be deleted. No. What deletion? Deletion is not required.
that will-
Retired. It was the challenge remains. It is subject to.
No, but you should not, all of you should not, you should give him some breathing space, Mr. Das.
Yes, madam. I am not having any breathing space these days.
No, that's
Because
also,
I had to counter Bhawan, but 7 lawyers were against me. It was very difficult. Just like the African jungle.
That shows his strength, my lord. He's
No, not
quite
strength.
very strong.
But it was very difficult. Just like the African jungles. One pitted 7 pitted against 1. Even
But
the government, which is a benevolent
but the
government,
king of Africa knows how to deal with.
but one judgment has gone in my favor, definitely. But I have not been able to get the fruits.
All right.
Say it, yes.
Mr. B. Chakravarti, learned counsel is present on the petitioner and submits that this contempt case of 2015 and he has lost contact with his client. After going through the
It's a reconsideration by the state level committee. That was the
Order
directive.
dated 10/12/2014 passed by the learned single judge in WPC number 6469 of 2014. This court is of the opinion that either the petitioner has already got his relief or this matter itself has become infructuous due to lapse of time. As such, this contempt case is closed.
May I please, Your Lordship? The writ petition may be taken up, Lordship, first, because in that writ petition, my learned friend is saying that similarly situated person approached the honorable court.
My lord, the persons who have been appointed by the Hospital Management Society, my lord. So in respect of that, whether the benefits of Upendas will be covered or not, my lord, regarding that issue, my lord, already another decision has been decided, my lord.
We
Your
have
lord.
a copy of it.
So she is agreeing with this my lord judgment because her issue case is equally covered because the petitioner is, my lord, appointed by the Hospital Management Society as a health worker, my lord. Appointed
So
on
what is, first of all, why this contempt case?
contempt case, my lord, there were against the order dated, my lord, 25/5/2018, my lord. Otherwise, he has been continuing, my lord, and
She has been continuing as what? Director of Medical Education.
No, Lordship.
Then?
She was appointed by the managing committee of the hospital, Lordship, as health worker.
As?
Health worker, Lordship.
All right.
That was not a regular Lordship. She was continuing in the year Lordship 2018 Lordship. 2018 Lordship, there was an advertisement with an intention to disturb her position, Lordship. She approached this honorable court. This honorable court passed an order, Lordship, protecting her interest, Lordship. That order in writ petition, Lordship, 25/5/2016, 18, Lordship. Where in which this honorable court granted some relief in person to Upendas order, Lordship. Thereafter, they were not giving the minimum wages, Lordship.
So petitioner is continuing now
Yes, Lordship.
as health worker.
Lordship.
Then why this contempt case?
No, Lordship. Actually, she was thereafter several orders are passed saying that her position shall not be disturbed. But they are continuing transferring her and disturbing her. That is why this contempt was filed, Lordship. And minimum wages were not given to her till date. And they are not. They are saying that in writ petition, the similarly situated some persons approached this honorable court, Lordship, who were also appointed by.
So she has been transferred from Eskeroy Civil
No,
Hospital.
from department to department to sweeping department, Lordship. She is a health worker in a maternity.
that can be done, my lord. Her basic grievance was that she was not paid the minimum wages, my lord, against that contempt petition.
But is there a direction to pay the minimum?
No,
wage?
my lord.
Lordship.
So we'll close this contempt case and
Lordship.
look at what is there in the writ petition. Not
Yes,
Ms.
sir.
S. Kanungola and counsel for the petitioner. Alleging willful disobedience of the directions contained in order dated 25/05/2018.
But there was a direction to give minimum wage of, Lordship.
Where is the direction?
Lordship, may kindly taken of content petition page number 17, Lordship, para.
Where is the direction in the order of the court?
Yes, Lordship. There is an order of this one of the court. Page number 17 of my contempt petition, Lordship. Minimum.
How many
Accordingly-
orders are there? You have
Several orders protecting her, Lordship. Even then they're not paying the minimum wages. Page number 18, para number 9. Accordingly, present application is allowed by directing the respondent authorities to ensure that petitioner to give minimum scale of pay attached to the post of health worker, so long as she continues in the post. But they were not giving, Lordship. That is why this contempt was filed.
My lord, again, regarding that issue, we have filed one review application, my lord. IA number 4291/2019, my lord, that is also listed. Because in the review, we sought for review of that part, my lord, because the petitioner being a appointee by the management, hospital management authority, she is not entitled for the benefits under Upendas. Because the direction was passed to.
Where is the review? Let's see.
IA number 4291/2019.
Review.
Not review, my lord.
Vacation.
Vacation modification of cancellation of the order, my lord. IA 4291/2019, my lord.
No, where is the question of vacation? This has to be reviewed.
Modification, my lord, because the observation by this honorable court that she is entitled for the benefits under Upendas. So my contention in the IA is that, my lord, that she is not entitled for the benefits under Upendas because she has been appointed on contractual basis by the hospital management society. And the persons who have been appointed by the government, only they are entitled for the benefits under Upendas, my lord. So that is on that ground, my lord, we have filed this IA for modification of the order, my lord.
In the meantime, Lordship, similarly situated person, my learned friend has informed me, approached this honorable court. This honorable court has given some observations in favor of the petitioner's lordship,
Where is
saying
it?
that it is I have here also.
Yes, my lord.
There are 22 and 23. They were also appointed by hospital management lordship. And in this, their case also, Upendas is applicable. This judgment has said that.
Paragraph 22 and 23,
23.
my lord.
So you are agreeable that this is applicable to their case?
Yes, my lord, because she has been appointed on the contractual basis by the hospital management society, my lord.
And what is there in the writ petition?
Petition lordship, she was appointed. I have annexed some certificates saying that she is continuing lordship
2002.
since 2002. This is the only livelihood she is having, lordship.
So in the writ petition, you have not paid for minimum scale. That is
Lordship,
not.
at that period of time, there was an advertisement regarding my post, lordship, attached to my post. So I challenged this advertisement. Gradually, when the writ petition came up, this honorable court said that I am covered by Upendas case and has given some relief to me. Thereafter, they're saying that since we are, appointed, she was appointed by managing committee, and the case is pending before division bench. So we were waiting for the result.
Which is the Upennath case? Where is the judgment?
Judgment I have, lordship.
So in the writ petition, what is the relief you are seeking?
I was seeking that my post may not be disturbed, lordship, and I may be considered for that, a person to that advertisement. That has gone, lordship. Now I'm continuing.
All right, so we'll dispose of the writ petition in the light of.
Yes, lordship.
Take down heard Mrs. Kanungal in the writ petition. Heard Mrs. Kanungal, learned counsel, appearing for the writ petitioner. Also heard Mr. D.P. Bora, learned standing counsel, Health Department, Assam, appearing for the respondent numbers.
All the respondents.
Appearing for the respondents. Full stop. The writ petitioner hearing was appointed as a ward girl.
Health worker.
Huh?
She was
What is-
health worker.
Appointed as a health worker in the SK Roy Civil Hospital, Hailakandi, in the month of April 2002. And since then, she has been rendering service in the said post till today against the fixed pay, against a fixed pay. First of earlier, there was an attempt to fill up the post held by the petitioner by selecting other candidates, and accordingly, the authorities had issued advertisement notice dated 14/12/2017. Full stop. 2017, which was challenged by the petitioner by filing the present writ petition. Full stop. After hearing the submission of the parties, this court had passed an interim order dated 25/5/2018, inter alia providing that the petitioner's services as health worker in the SK Roy Civil Hospital would not be disturbed till the returnable date. Full stop. The order dated 25/5/2018 was evidently passed by the learned single judge by taking note of the fact that since the petitioner had rendered over 10 years of continuous service as health worker, she was entitled to interim protection as per the ratio laid down by this court in the case of State of Assam versus Upen Das, reported in 2017 bracket close 4 GLR 493. First up. Consequent to the order dated 25/5/2018, the petitioner has been allowed to continue in service in the post of health worker, although it has been alleged that from time to time there has been intra-departmental shifting of the posting of petitioner. Full stop. Full stop. Mr. Bora, learned departmental counsel, submits that since the petitioner was appointed by the
Hospital Management
by the
Society
Hospital Management Society and not by the state government of Assam,
on contractual basis.
a Hospital Management Society on contractual basis and not by the government of Assam. Hence, her case would not come within the ambit of the decision rendered by the division bench in the case of Upen Das and others, bracket Supra. Full stop. Mr. Bora has, however, not denied that in view of the decision of this court rendered in the case of Jadumoni Nath, JADUMON, Jadumoni Nath and others versus State of Assam and others. Bracket WPC number 7711 of 2016. Even those candidates who were appointed by the Hospital Management Society would be entitled to consideration of their case.
For payment of minimum pay.
For payment of minimum pay scale. Ms. Kanongo submits that her client would be satisfied if she is allowed to continue in the present post and pay the minimum pay scale. Full stop. Next para. In the case of Jadumoni Nath Supra, a similar issue came up for consideration before this court. Full stop. After considering the decisions, various decisions rendered on the issue, the learned single judge had disposed of the writ petition being WPC number 7711 of 2016 by order dated by judgment and order dated 10/11/2022. The operative part of the judgment is reproduced here and below under reproduced here in below para 23 to colon, full stop. Since there is no wrangle at the bar, that in view of the decision rendered in the case of Jadumani Nath, the petitioner would be entitled for payment of minimum scale, pay scale. Hence, this court is of the opinion that minimum pay scale, and considering the fact that the petitioner has admittedly been working as health worker in the SK Roy Civil Hospital, Al Hailakandi, since April 2002 till date. Hence, neither the question of dispensation of her service at this stage will arise, nor can the petitioner be denied the benefit of minimum scale of pay. Full stop. In view of the above, this writ petition is hereby disposed of by directing that the case of the petitioner shall be considered in the light of the judgment rendered in the case of Jadumani Nath Supra, and appropriate order be passed in that regard within 3 months from the date of receipt of a certified copy of this order. Writ petition stands disposed of accordingly. In view of the order dated so and so passed in WPC number 3330 of 2018, this IS stands closed as infractious. Our contempt case, since the learned department, learned counsel for the respondent has submitted that in terms of the interim order dated 25/5/2020, 2018, the petitioner is continuing in service, and considering the directions issued by this court by order dated Azir order passed in WPC number 3330/2018, the petitioner's case would be considered afresh. I am of the view that there is no justification for keeping this contempt case pending before this court. Full stop. The contempt case is accordingly closed.
Petition order minus 26/4/2021 minus page 19 and extra 3 minus. The vital part is minus page 26. Petitioner was the suspended under Rule 6(2) under Assam Service and Disciplinary Controversies. My lord, he was suspended on 7/12/2019. My lord, the petitioners, the department not reviewed, my lord, and in this regard, my lord, petitioner said, my lord, the report is an honorable court, my lord.
So what has happened? The petitioner was suspended.
Yes, sir.
When?
He is 7/12/2019. Is an annexer, my lord. 1 page 12.
And he is still in suspension.
Yes.
And what is the direction by the single judge?
Single judge, my lord, as per the my lord, the order, my lord, paragraph 21, my lord. In view of the aforesaid facts and circumstances, this court has no other option but to follow the decision of the division bench in the case of Zakibuddin Ahmed Chopra. Accordingly, the orders of suspension which are not reviewed within a period of 90 days and where the so-called notice has not been issued are set aside and passed. This court would also like to add the observation that no prejudice whatsoever would be caused to the department in as much as no blanket order of revocation of suspension is passed, and it is left to the departments to make periodic review within a period of 3 months and to decide as to whether such suspension is required to be extended by assigning regions. Further, in tune with the observation of the division bench, this court is also having to add that the respective departments will be at liberty to transfer the petitioners in any sensitive.
So where is the order of the petitioner which has been quashed? Which part is that? What is the date of the suspension order?
That is
7/12/2019.
That is Annex R1, page 12.
Was the order dated 7/12/2019 quashed?
Yes, sir.
Where is the observation?
Lordship, paragraph 4, kindly see, Lordship, page 19, Lordship.
Paragraph 4.
Lordship. It was a group case, my lord, order of the group order, my lord.
Lordship, an appeal against this order, an appeal has been preferred, Lordship, that has been admitted. And on the very first day, Lordship, it was paid before division bench to issue a status quo order or stay order, Lordship. He was also present on that day.
Not a stay.
And, no, under honorable court remarked that I am here, don't worry. He was there on that day itself, Lordship. So appeal has been admitted already, Lordship, it is pending.
That is different, my lord, but not.
Is there any interim order in the appeal?
No, that is.
No.
No interim order.
No.
Then appeal preferred when?
Immediately, Lordship.
After filing the contempt petition, after issuing the report. And law, before this honorable court, law is clear, my lord, that the Megan Halley also case is a clear date.
So if there is no stay, order has to be implemented.
Lordship.
Let them come personally. Who are the contemners? They have to explain it to us.
But that specific remark was there by the honorable Chief Justice.
Oral.
Yes. My colleague was also present.
No, that not. Let them come when they want to come.
This matter came up for hearing only recently, Lordship. It will come very shortly, it will again be listed.
No, but if there is no interim order, then the order the court has to be complied with. Is that not?
In fact, no, it is not, the department is not willing to comply, Lordship. It is because of our, actually, that influence by the honorable court, Lordship. That is why it has not been done.
No, these things don't work. What the verbally who has said we are not concerned.
Then Lordship will grant me some time, Lordship. On the next day, let us again pray for this honorable court, Lordship, on before the division bench, Lordship. Until then, Lordship.
What is the appeal number?
Number
114/2022, Lordship.
114 of 2022.
Lordship. Yes, 114/2022.
No, but this law is settled by Supreme Court.
That is the only issue, nothing else.
What is the issue?
That honorable Justice oral instruction. Instruction means he was also present. He said, Lordship, I am here, don't worry.
Honorable Chief, who is the honorable Chief? Which honorable Chief Justice?
22 law.
Huh?
22.
No, but is there a court order?
Not written.
Then there is no order. Or you bring the Chief Justice to us, otherwise we will not be able to agree. How is this court going to go into that?
Yes, Lordship, that is.
All right. I heard Mr.
Ellen
Dehingal and counsel for the petition, alleging willful disobedience of the order dated 22/4/2021, passed by the London single judge in WPC number 853/2022.
No,
Whereby
my case is a double fact with three, Lordship. This is a brief case, my lord. 5523 of 2022. Page 17, Lordship.
5523 of 2022. Bracket Ajit Sonowal versus State of Assam and others. Bracket close. Whereby the order of suspension of the petitioner was set aside, and a direction was. Is there any direction to reinstate him?
Yes, Lordship. Paragraph 21, Lordship. Set aside and court. And all the writ petitioners are already, my lord, reinstated by other department.
Other writ petitioners have been reinstated.
Yes, sir.
I am concerned with only with the finance department. Other
The home department already reinstated.
Where is the operative? Which paragraph? Which page?
Page 26.
was set aside by the learned single judge. The present petition has been filed inter alia contending that whereas the department has reinstated all other candidates pursuant to the order dated 22/4/2021 passed by the learned single judge in a batch of writ petition. Only the petitioner's case has not been considered for reinstatement. Full stop. Responding to the above, Mr. P. Nayak, learned counsel appearing for the respondents, submits that a writ appeal has been preferred by the department against the judgment dated 22/4/2021, which is pending disposal before the High Court. But Mr. Nayak has submitted in his usual fairness that no interim order has been passed by the division bench. Full stop. If that be so, the respondents were duty bound to comply with the court order and reinstate the petitioner. Full stop. But the same has not been done in this case. Full stop. Therefore, on the face of the record, there is willful disobedience of the order of this court. Full stop. In view of the above, this matter is, in view of the above and on the request of Mr. Nayak, this matter is directed to be posted again on 3rd March 2023 as a fixed item. If by the next date, the order of this court is not complied with qua the petitioner, then the respondents shall remain personally present before this court. Full stop. The order of this court be communicated to the respondents.
Item 45. 45.
My lord, I am appealing for the respondent.
Similar matters were there other day.
Yes.
Heard Mr. S. Dr. Learned Counsel for the petitioner, also heard Mr. A. The Learned Counsel will submit that he has recently entered appearance on behalf of the respondent by filing Wakalatnama and therefore be granted 3 weeks time to obtain instruction and file affidavit. Prayer allowed, please accordingly.
Item 46.
My lord, on behalf of respondent number 1, he is appearing, my lord. 2 and 3, my lord, not appearing.
You are appearing for?
For the petition, my lord.
My lord, 3 weeks time you will granted to file affidavit, my lord.
My lord, what has happened, my lord? This is regarding my lord revised pay scale. And the person
For
is
the first
already
time,
retired, my
I'm
lord, in
appearing, my lord.
2021, my lord. And he is not getting his revised pay scale, neither he is, my lord, he is being able to process his pensionary benefit, my lord. And 3 weeks time was given to do the needful, my lord, at his at page, my lord.
That you heard Ms. M. D. Chaudhary, Learned Counsel appearing for the petitioner, also heard Mr. A. Bhattacharjee, Learned Counsel appearing for the respondent number 1, who prays for and is granted 3 weeks further time as last chance to file affidavit. Full stop. If no affidavit is brought on record within 3 weeks, the matter will be taken up for final disposal on the basis of materials already available on record. What is
The first time only, my lord.
All right,
It's
all right.
okay. Obliged, my lord.
Item 48.
May I please, Your Lordship? Your Lordship, in this matter, if I may state the facts of the matter, Your Lordship, briefly, Your Lordship.
No, you state, but also say, why are you stating it? What
Yes,
purpose?
yes, Your Lordship. In fact, we had prayed for a stay in the matter. The ATCL was in the process of leasing out 12 of its tea gardens to private lessees.
Is it fixed for interim order today?
This was fixed for an interim order, Your Lordship, but we have not received the instructions as of now.
You are for whom?
I'm for the petitioners, Your Lordship. I'm for the petitioners.
So you want time?
I do not want time, Your Lordship. I can pray for the interim, but my friends have not furnished the instructions.
Yes, we have not furnished the instructions, Your Lordship, and
We have not been given a copy, I believe, Your Lordship. I hesitate to be very positive in this regard, but we have one copy which my learned friend had given me on that very day. But extra copies perhaps.
We have taken
it's
steps
not-
as per the court's order, Your Lordship.
On ATCL, I respond number 2. In any case, Your Lordship, I pray for.
The issue here, Your Lordship, if I may briefly state, Your Lordship, that Your Lordship, if you can kindly come to page 66, only one page, Your Lordship. I'll not take you, trouble Your Lordship further, Your Lordship. Page 66. Page 66. Page 66.
Yes.
Page 66, Your Lordship, is a part of the pro forma lease deed which the ATCL will enter into the will enter with the private lessees. Clause 5, Your Lordship, states in the middle portion, Your Lordship, that with immediate effect from the date of handing over a possession or the deemed date of handing over a possession, the lessee shall take over the employment of the employees and shall be responsible for the due fulfillment and maintenance of all employee obligations, including the salaries. We are concerned with the salaries, Your Lordship, because the issue of the petitioner's salary was subject to this Honorable Supreme Court's final adjudication. The Supreme Court delegated the matter to a one-man committee to be headed by Justice Retired Abhay Manohar Sapre, Your Lordship. His orders clearly indicate that we are entitled to the area payments. We wanted a stay, but as we understand, the lease has already taken place, and we are not challenging the policy also. What we basically wanted from this court was a direction that we be paid our area dues in accordance with the one-man committee's report, and then the handing over takes place. Now the handing over has already taken place, so I cannot argue on that. But in that matter, Your Lordship,
So what is the interim order you want?
we wanted the handing over to be stayed till the area dues are finally calculated. But since there was no stay, and the ATCL has carried out with the handing over, and now 6 out of those 12 tea gardens have already been leased out to the lessee. But
this is a government corporation.
It's a government corporation, Your Lordship. What has happened is that they're not being able to run the tea gardens due to a lot of other factors. So in order to increase productivity, the growth of the tea sector, they've leased out.
So what will happen? Supposing your interim order
Yes.
there is considered by the court
Yes.
and the lease is stopped,
Lease is
then
stopped.
what will happen?
What happens is that by then, Your Lordship will kindly come to one more page if Your Lordship has saw this.
Will you tell me first?
What has happened is, Your Lordship, at the time of handing over, the lessee, the new lessee, takes over all the existent payment obligations. Now, the 5th, 6th, and the 7th pay commission of the petitioners, including the workers as well, were not paid by the ATCL. The matter was before this Honorable Supreme Court. The Honorable Supreme Court directed that the payments be made. Thereafter, the payments were not made. A contempt petition was filed. Thereafter, this Honorable Supreme Court, Your Lordship, delegated the entire responsibility of computing the arrears to a one-man committee to be headed by Justice Retired Abhay Manohar Sapre, Your Lordship. He was here, Your Lordship. He conducted regular weekly hearings, and finally he furnished his report. In that report, the ATCL initially contended that we are not entitled to be paid our area dues. We submitted an affidavit, and our claims, along with the workers and the workmen's claims, were all taken into account. And Justice Abhay Manohar Sapre had clearly, categorically, Your Lordship, dictated that the ATCL's dues are not tenable, and we need to be paid our due areas. At that point in time, the lease was not in the picture. Subsequently, the government carried out the process. Now, we are only aggrieved by this particular clause. Now we understand that maybe we're past that stage where I can ask the Lordship or can request a Lordship for a stay because the lease has already happened. And we're not against the policy of the government. Absolutely not. What we are is that even if the lease has taken place, at least we be computed and given our area dues.
What happened to the proceeding in Supreme Court?
The Supreme Court is still in session of the matter. The one-man committee has sent its report, and it is before the Supreme Court. The
So
matter
your clients basically want their salary, area salary.
want their area salaries. We have a secondary prayer also to be absorbed in a government undertaking now because we have reached that stage in our careers where we cannot change.
So
shift.
if you have a proceeding pending in the Supreme Court on the issue, why should we entertain another proceeding in the High Court?
No, the issues were different there. The issues was regarding payment of area dues. Here we are trying to enforce the fact that the area dues need to be paid before the handing over takes place. We are aggrieved by this. We are aggrieved by the proposition in the lease pro forma
which states that all the existing obligations till the handing over of date.
So what will happen if it is handed over? That's what I'm asking you.
It has already been handed over. Your
If
Lordship.
it is done, then your clients will not get the relief.
This is what the agreement between the ATCL and the private leasing states, and this is why we agree. This is why we have come before this court to.
Where is that law? ATC cannot shun his responsibility by entering into a private agreement with another.
We'll be grateful if your Lordship
Yes,
observes
this is
that.
but then we will not touch this matter. The Supreme Court is in session.
The Supreme Court in
Yes,
session.
you are interested in your salary and allowance, not anything else.
Also, the fact that we may be absorbed in separate. government
Whatever, you
undertakings,
take all this plea before the Supreme Court.
It's a consideration that is not before the Supreme Court, your Lordship. They already.
Amend your petition, take it. You can't do it in a piecemeal manner. If the Supreme Court is entertaining your plea and hearing the matter, what order can the High Court pass now? You should point it out. They are not pointing it out. I don't think the single judge should entertain this petition at all. Mr. Chaudhary, the whole issue is subject before the Supreme Court.
The Supreme Court, my lord, actually, we did not approach the Supreme Court. One association approached, and thereafter, my lord, there was a direction that the amounts should be calculated because there were non-permits, a large number of my lord tea garden employees, and the separate commission was my lord appointed, and separate commission has given its report, and there is a direction to calculate the amounts that those are payable. So that was where my lord, before the separate commission, we appeared. And we filed our affidavit, it was considered, and whatever points were raised against us by the ATC, those were rejected.
You are not party in the Supreme Court proceeding. No, but association is of employees only.
My lord, the workers and workmen, my lord. So we
Anyway, I'm just pointing it out because the only order this court will pass is adjourn it. Either it is today or tomorrow. Other things we are not concerned. Your only right is to receive your
my lord,
salary.
actually, what happened, my lord, there were 12 gardens which we were concerned about, and 12 out of 12, 6 gardens have already been handed over. So we do not, my lord, really pray for the stalling of the handing over. Half of it has been done. Now, half if we pray also, my lord, that will not really give.
That cannot be
really.
granted.
Therefore, perhaps, my lord, the only thing is that calculation part has not been done by dame date, and there is my lord, there is an undertaking that they will pay before it is handed over. So that has not been done. Let them file an affidavit. Perhaps, my lord, that will be
Well, I will go on, but this court will not pass any order in this case because the
on
Supreme
the
Court
last
is-
occasion, my lord, the court finished the matter.
They are not pointing it out, but you should point out before the judge.
No,
I don't know why.
in the initial, at the initial stage, my lord, regarding the question of maintainability also, it was raised, my lord.
No, it is not so much on the ground of maintainability, but it is on the ground of propriety. When the Supreme Court is entertaining and looking into the same
The
issue.
Supreme Court has, my lord, appointed a commission, and that commission has issued certain direction.
Has Supreme Court washed off its hands?
Not yet.
Then,
Contempt is pending. my lord. The main matter is gone, only contempt is pending.
all right, I heard Mr. M. K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel appearing for the petition. Also heard Mr. C. S. Hazarika, Learned Government Advocate Assam, and Mr.
I'm N. Kalita on behalf of Mr. A. Kalita, Industries.
N. Kalita, Learned Counsel appearing for the Industries Department, both of whom have prayed for another 3 weeks' time to obtain instruction and file affidavit. It has also been pointed out that the proceedings pending before the Honorable Supreme Court on the question of payment of arrears, salary and allowances to the petitioner has not yet been disposed of.
No, my lord, that matter has been disposed of, then separate commission has given the report, contempt is pending, man.
Has been disposed of, but after the report of separate Justice Separate Committee has been submitted, the contempt case is still pending.
Extra copies may be submitted.
He
We
says.
have already served, my lord. Okay, that will provide, my lord.
Neither of us has got it, that's the.
Will not record it in.
Yes,
the-
my lord, Nine बार हो गया, आज भी हम मौसम की है। All right.
Party matters, item 3.
Yes, what is it? What is this matter?
Lordship, the state has filed an appeal against the order of the administrative tribunal, Lordship, against the Lordship, my petition, my application was allowed for stepping up of pay, Lordship. Huh? Oh, stop now. It is 3. I think 3.
Yes.
Lordship will find the impugn order at page number 30, Lordship. That starts from page number 29. The operative portion is page 30.
Lordship, in this case, Lordship, respondent Sapna Rutta was claiming equalization of her pay to respond number 4. And her ground for claiming equalization is a notification issued by the finance department at page number 55, Lordship.
1 minute. Yes,
Like-
1 minute.
Annexure. Second paragraph, Lordship. Equalization of pay of senior government employees or stepping up of pay of senior government employee with juniors is admissible on the following cases only. It is therefore impressed upon all the administrative department to examine each proposal carefully and refer to finance department only those cases which fulfill the following points. 1, both the senior and junior government employee whose equalization stepping up of pay is proposed should be recruited to the same cadre post initially and should be promoted from the same source. That word promotion, Lordship. Lordship, initially both.
Just a minute, I'm going through the impugned judgment. I'll come back to you.
Lordship, initially, the appellant was respondent, Lordship. She was initially appointed as a grade 3 stenographer on 25/6/1983. Then, Lordship, on 29/11/1986, she was recruited to the post of stenographer grade 2. Lordship, I'm using the word recruited, not promoted. Then, Lordship, on 31/3/1992, he was recruited to stenographer grade 1. Lordship, on the other hand, Lordship, respondent number 4, she was appointed as stenographer grade 3 on 14/7/1983. Then stenographer grade 2 on 30/9/1985. Lordship, in this case, Lordship, respondent number 4 was recruited to stenographer grade 2 prior to the respondent, Lordship. And finally, she was recruited to the post of stenographer grade 1 on 16/9/1999. And the claim of the petitioner is that as she was promoted from grade 3 to grade 2 than grade 1. And both of them were earlier at the level of grade 2. On being promoted, she should get, her pay should be equalized with that of respondent number 4 also. That is her pay.
So what is the finding of the tribunal?
Lord, may I kindly see at page 32. Sorry, Lordship, 31. Last paragraph, Lordship. The fact projected in the appeal are not in dispute. The date of entry into service and appointment to the various cadres of the service in the case of the appellant and the respondent of 4 are also not disputed. It is seen that the appellant was appointed to the stenographer grade 1 of the service on 2/4/1992, while the respondent of 4 was so appointed only on 16/9/1999. The appellant is senior to the respondent of 4 in the cadre of stenographer grade 1. In the normal course of things, there being an admitted disparity as regards fixation of pay between a senior and a junior, the same could have been resolved by applying the express provisions of the office memorandum dated 10/9/1997. However, in the present case, having been
raised.
A plea
having been raised by the
plea
official
having been
respondent
raised by the official respondents that the
said
said
office
office memorandum
cannot be applied.
cannot be applied to the dispute involved in the present proceedings on the ground that the said office memorandum only takes within its sweep disparity in fixation of pay resulting from promotions and not appointments, as is the case in the present proceedings. For appreciating the said contention, we have carefully perused the provision of the Assam Stenographer Service Rule 1995. Although the said rules denote the advancement in service career as a incumbent recruited as stenographer grade 1 as appointments on his recruitment to the stenographer grade 2 and stenographer grade 1, we find that the word appointment denoted as regards the recruitment to the said cadre of stenographer grade 1 is in fact a promotion, inasmuch as for being eligible for recruitment to the stenographer grade 1. Amongst other, a candidate must figure in the cadre of stenographer grade 1 or stenographer grade 3 of the service. The said aspect of the matter would show that stenographer grade 2 or stenographer grade 3 constitutes a feeder cadre for recruitment to stenographer grade 1. The method of recruitment to stenographer grade 1 as provided for under the said rules of 1995 has all the taping of promotions. Accordingly, the use of the word appointment in the orders issued towards recruiting the appellant or the respondent for to the cadre of stenographer grade 1 would not make the same a direct recruitment. As such, we are of the considered view that the recruitment to the cadre of stenographer grade 1 of the Assam Secretariat Administrative Service is in fact promotion. Having reached the said conclusion as regards the objection raised about applicability of the office memorandum dated 10/9/97, we hold that the provisions of the said office memorandum is attracted to the facts involved in the present proceedings. In view of the conclusion reached by us as regards the applicability of the provisions of the said office memorandum dated 10/9/97, we now examine the grievance of the appellant based on the provisions of the said office memorandum. It is not in dispute that the appellant, as contended in the appeal memo, is drawing her pay at a lower stage than her juniors, that is the respondent of 4, in the scale of pay of rupees 5,725 to 11,825 prescribed for the post of stenographer grade 1. The appellant and the respondent number 4 having been recruited from the same cadre to the post of stenographer grade 1, and they having been recruited initially to the same post of stenographer grade 1. The case of the appellant for equalization of her pay with that of her junior is the
In the cadre of.
in the cadre of stenographer grade 1 is squarely covered by the provisions of
So
clause.
according to you, it was direct recruitment, not promotion.
It is recruitment, Lordship.
Recruitment.
That is clear
Right.
from the
You show us the advertisement notice. When was the advertisement issued?
advertisement is not there. I'm going to the rule, Lordship.
No, you have to show us.
Advertisement I have not. In the rule itself, Lordship, that has been
No,
mentioned.
expression appointment, we know how the rules are made.
Lordship.
Appointment means it has to be direct appointment. Are you saying that from grade 1 to grade 2, grade 3 to grade 2, you are issuing advertisement, calling for applications,
No,
holding a written
Lordship,
test, selection
That
test?
is what I'm trying to emphasize, Lordship. It is not necessary that to get to be recruited to the post of grade 1.
That is wastage of time. We'll not hear these arguments. If you say that you have gone for direct recruitment, show us the materials. Otherwise, we can't disagree with the
No,
finding.
it is clear from the rule itself, Lordship. Just two rules, Lordship.
Yes. That has been interpreted by the tribunal that the
No,
expression
that
appointment
there,
would mean.
in my
promotion.
humble submission, they're wrong committed there, Lordship.
Yes. Where are the rules? Which page?
Lordship, rule 35, page 35, Lordship. Lordship, here, Lordship, rule definition clause, Lordship will see the appointing authority and classes are there, stenographer grade 1. In case of stenographer grade 1, appointing authority is the government, and in case of stenographer grade 2 and grade 3, secretary is the appointing authority. Then Lordship may come to page 38. Page 38, 5. Recruitment to the various cadres in the service shall be made in the manner prescribed hereinafter, namely. One is special officer, I'm not concerned. Lordship may see serial number 3. Stenographer grade 1. Lordship may kindly see by recruitment in accordance with Rule 6 and Schedule 1 of Part B. Stenographer grade 2 by recruitment in accordance with Rule 6 and Schedule 1 of Part B. Similar is the case of stenographer grade 3. But Lordship will see at serial number 1 and serial number 2 by promotion from senior grade stenographer. So in case of Lordship, first two cadres, Lordship, the expression promotion has been used. But in case of stenographer grade 1 and stenographer grade 2, the word recruitment has been used. Lordship may kindly say Rule 6. Appointment.
So according to the rules, these are direct recruitment.
It is clear from that. It is not direct recruitment.
You're right. What has happened here? Was it a direct recruitment?
No, qualification is necessary, Lordship. That is why I'm coming to Rule 6, Lordship. Appointment to the cadre of stenographer grade 3 shall be made by direct recruitment, and the cadre of stenographer grade 2 and stenographer grade 1 shall be filled up by recruitment in accordance with the procedure as provided in the rule. For appointment to the stenographer grade 1 from stenographer grade 2, one should complete 6 years of continuous service in either or in both the cadre of stenographer grade 2 and grade 3. The appointing authority shall make the appointments on the basis of the recommendation made by the commission in accordance with the procedure hereinafter provided, namely. So this is the procedure mentioned, Lordship. Lordship here will see. So for promotion, for recruitment to the post of grade 1, one needs to have 6 years of service, either in the cadre of grade 3 or in the cadre of grade 2. Then Lordship will come to schedule, Lordship, at page 50. Page 50, Lordship. Lordship may kindly see Schedule 1, Part B. Qualification for recruitment. The minimum qualification and experience for recruitment to the cadre of the service shall be prescribed below. Stenographer grade 1, pass the degree examination or an equivalent examination from the recognized university, from a recognized university. 2, candidates should complete 6 years of continuous service, either in the cadre of stenographer grade 2 or stenographer grade 3, or in both, on the 1st January of the year of examination. Lordship, it means stenographer, you don't need to have your service experience at stenographer grade 2 level to be recruited to the post of stenographer grade 1. Even if you are working as stenographer grade 3 for more than 6 years, Lordship, you can be recruited to the post of stenographer grade 1. That means, Lordship, stenographer grade 2 is not the feeder cadre of stenographer grade 1, as was mentioned in the tribunal, Lordship. In the
Mr. Nayak, all these things put together, let us assume that it is correct. Even then, how can you give a higher pay scale to somebody who becomes a grade 1 at a later date? By what analogy, what application of rule it is
Yes,
permissible?
Lordship. Page 64, Lordship. Here we have given a detail, Lordship, scale wise. Page 64. Let's see the table.
Page 64.
64. Lordship, may kindly see the first one was the writ appellant, Lordship. She is respondent 4 now. Joined as stenographer on 2683 in the scale of 375, 15, etc., etc. On 19683, 375 revision of pay scale for grade 3. Then in the last, Lordship may see the date 1/6/1986. Our scale was at the level of 750. Next box, Lordship, recruited to grade 2 on 29/11/1986, Lordship. The pay scale for grade 2 was starting from 670. And on 29/11/86, Lordship, when she got promoted to the, recruited to the post of grade 2, her scale was fixed at 810. Next, Lordship, on 1/11/1987, it became 845, and 1/11/88, it became 880, Lordship. Then revision of pay again came on with effect from 1/189, senior grade 2. Then it continued like that. On 1/11/1991, it became 2155. This is pre-revised, Lordship. Recruited to stenographer grade 1, pay scale at the pay scale of 2275. It started from 2155, Lordship. On 1/11/1991 was the last pay drawn by the respondent 4 at the level of grade 2. On being promoted to the on being recruited to grade 1, our scale was fixed at 2275. It continues like that, Lordship. Lordship may see in the next page also. I'm going up to 1/4/1999, Lordship. 1/4/1999, her pay was at the level of 6850. Page 65, Lordship. Grade 1. On 1/4/1999, her pay was at the level of 6850. In the next column, Lordship, this is the employee, Lordship, in respect of which she joined as stenographer grade 3 on 14/7/83. It continues like that, Lordship. She got promoted to stenographer grade 2 on 30/9/1985, and pay scale was fixed at 775, Lordship. Now, in this column, Lordship will see the pay scale, Lordship. On 1/9/1991, her pay was 2155, Lordship. Lordship may compare that with that of the respondent 4, Lordship.
On the date on which the private respondent in the original proceeding was appointed as stenographer grade 1, that is 16/9/2099.
Yes, Lordship.
On that day, the present respondent number 4, that is her client, she was already serving as a stenographer grade 1.
Yes, Lordship.
Correct?
Yes.
Then suddenly how the pay scale of the other person went up?
Not went up, Lordship. It's serially it's going on. Lordship may see on 1/9/1999, the pay of the other person was 6850. It is same, Lordship. 1/4/1999, the grade pay of the appellant, Lordship, before the tribunal, it was 6850, and that of the respondent, Lordship, was 6850.
So you mean to say the respondent in the original proceeding never got higher pay scale than the petitioner.
It shows lots of. It shows lot. Even there are also now also lots of there are persons who are even stenographer grade 2 are getting more salary than stenographer grade 1 also.
Are you clear on these matters? If you are not clear, you better examine it, because I'm not going to hear this matter twice.
Lordship may fix next week, Lordship.
All right, let's take it. You make a table, what has happened.
Lordship here, Lordship next week, Monday or Tuesday.
Lordship, my senior Mr. Yukina appears in this item
Hmm?
4, Lordship.
Hmm.
Lordship, he is not present today, so I pray for
Who is the senior?
Mr. Yukina, Lordship.
But this is a 2011 matter.
Yes, Lord. It's pending since.
What is this matter about?
It relates to promotional benefits, Lordship. He was serving in that post, Lordship, but he was not given the benefits, Lordship, of that promotion. Lordship. Lordship, in item 5, the records were called for, Lordship.
The records have not been received, Your Lordship.
Hmm.
Lordship, it was sometime.
Any matter, both sides ready? He's not here.
Yes.
Call him then tomorrow we'll take up tomorrow.
Yes, yes.
Yes, Mr. Roy, what is your matter? Which matter?
Item 14. The respondents.
We'll take